Shall we begin? Okay. Well, I'm told it's Bombay and it's normal to be half an hour late, but we have a slightly tight schedule, so we'll start and hopefully others will join as the evening progresses. I know that I've met some of you, but probably not all of you. So I'm Indranil. I'm one of the co-founders of Lexplosion, and it's very, very happy to have all of you here, and thank you so much for coming. I know it's Friday. I know it's still working day and working time for all of you. I also know it's the 7th of the month, so some of you probably have filings to do for the income tax returns. But thank you so much for sparing the time. I'm hoping that the day will be productive and we'll all learn something from today. Lexplosion was set up in December 2007. The outcome of poor decision-making skills of 4 ill-advised friends, one of whom was also here, who also happened to be lawyers. The cheap beer didn't help either. Seems like yesterday, at least for the few of us who have been there from the inception. But then I started thinking, where exactly was the world in 2007? And here's what I found. Apple had released iPhone 1, a 2G handset, the same year, in the month of June. Amazon was still largely an online bookseller. Airbnb was just an idea. And the likes of Uber, Tinder, Cyril and Shardul Amarchand did not exist. And of course, you could not be gay and happy at the same time till as recently as yesterday. To therefore stand here and say that we had planned to become a legal tech company when we set up would be a brazen lie that, barring our doting moms, no one else would fall for. We were in-house counsels with various GE businesses, grappling with challenges which I'm sure are similar to the ones that many of you face today, handling the business teams and their myriad idiosyncratic requests, handling labor inspectors, and worst of all, of course, handling senior counsels. In all of this, one of our biggest challenges was keeping track of regulatory compliances, particularly the state level ones. So we decided to set up a company which will focus on regulatory compliance management. This, as I mentioned, was in 2007. One of the first conferences that I attended after Lexplosion was born was actually a very large conference of NASSCOM in Calcutta, where the chief guest was Ramalinga Raju. A year later, Mr. Raju was telling the world about his experience of riding a tiger, and soon after landed up in jail. It was a turning point in the life of Lexplosion, which was at that moment fledgling. While Satyam was more of a fallout of corporate fraud rather than the lack of compliance management, it did wake up board members and CXOs to the risk of not having a measurable solution to managing compliances. Comrisk was still another couple of years away though. The outcome of an exercise of creating a grounds-up compliance database for the Indian operations of one of the largest FMCG companies, which had, I don't know what the numbers are now, which had 75 factories and offices in pretty much every state in the country at that point of time. And for the first time, we realized how large the entire compliance management space was, how diverse it was, and how difficult it was because of the lack of information something that we grappled with and something that we now use when we are trying to test out a new vendor in terms of whether they have all the information that we need. We ask them to provide us with the latest minimum wages rules for all the states. And we are yet to find a vendor who's been able to provide it. Anyway, once we started that exercise, in the interest of confidentiality, we'll not take the client name, though some of their past and present employees are here today. One of their senior counsels asked me a very interesting question. And I remember this very clearly. I'd come to Bombay and I was in his office and he said, "Do you know how many rows of data you have created for us?" And the answer was upwards of 50,000. And then the next obvious question was, how do you expect us to manage it? And that's where the thought of commerce came from. And I can, of course, keep on talking about the rest of Lexplosion's journey through 2009, 10, 11, and 12. But I thought we'll do something even more interesting, and which is a hopefully less boring experience for you. We'll roll out a video on Lexplosion. And I promise you that this will be the only time today when we'll be doing this brazen marketing. After that, we'll be a little more subtle, hopefully. So thank you so much for your time again. Thanks for coming. And we roll to the video now.
As your business grows, so do your legal risks. Risks relating to your regulatory compliance, customer contracts, ongoing litigations, and so much more. With almost every employee potentially contributing to these risks, trying to control them using manual checklists and isolated measures leads to inevitable failures. Enter Lexplosion, a pioneering legal tech company providing solutions to mitigate diverse legal problems across leading enterprises since 2007. From its inception, Lexplosion has adopted a client-first approach while marrying its expertise in the legal domain with the latest disruptive technologies. Backed by a team of legal, finance, and technology experts, Lexplosion's vision is to keep simplifying legal challenges with the use of technology so that in-house teams can focus on their core. Lexplosion has offices in Mumbai, Delhi, Kolkata, and Bangalore, and has alliances across the world.
One of the first challenges that Lexplosion mitigated was regulatory compliance management through its compliance suite of ComRisk, Complied, and Complify. Between the three, your compliance worries are so well taken care of that you can start thinking of the big picture once again.
When you're sitting out there, looking at the big picture, calling all the shots, it's not difficult to overlook the little details waiting to blow up on you. Take this innocent phone call on a late Friday afternoon. This could be your compliance officer with the news that some key contract workers have gone on strike. This could also be your consultant informing you of a show cause notice under a law that you didn't even know existed. There goes your weekend, potentially your reputation, or even your company's long-term existence. All because you aren't ComRisked yet. ComRisk simplifies the whole business of compliance by streamlining the processes in 4 clear steps. Tracking and updating compliances on a real-time basis. Setting up internal compliance processes by understanding how your business actually runs. Monitoring compliance execution through alerts and reminders. And reporting status and progress of key compliance matrices to the board using sliced and diced dashboards. ComRisk does not just protect your company's brand, it protects your weekends as well.
Not every large organization is ready for implementing a compliance solution though. Many need to first get an audit done to know where they currently stand, and Lexplosion has a solution for that too.
Your week begins with an email from the boss. Can I get a report on whether all our on-site vendors are complying with applicable laws by the end of this week? She asks. No, you think aloud before responding with a curt, "Sure, boss." There are a dozen offices and over 100 vendors, and you don't even know where to start. Welcome to Complied, Lexplosion's real-time audit management solution, and your best friend for the week. With Complied, you can commission an audit in minutes, control the pace and cost, delegate parts to different people in the company, view the status and progress of the audits in real time. Be sure that you are auditing for the latest applicable laws and compliances. Get granular assessment of non-compliances and corrective action plans, and obtain a comprehensive report in minutes. You can also add your own questions and use the tool for due diligence. Now that you have all the work set for this week and will have complied on time, maybe it's time for that celebratory meal on Friday evening. Have fun!
Both ComRisk and Complied are engaged solutions for enterprises with refined tastes, structured teams, and a reasonable budget. But what if you are a SME struggling with day-to-day operational and resource challenges? Lexplosion has a solution for you too.
A small Indian business, an office, a factory, a couple of sales offices. To compete globally, you need to be compliant. Obtain registrations, get consents, do ongoing filings. But with well over 500 compliances every year, the job at hand is difficult. Trying to keep pace with changing compliances can eat into your precious management time and be very expensive. But not complying can mean loss of business opportunities with larger companies, significant reduction in profits because of hefty penalties, reputational loss, and even jail. To avoid this, Lexplosion has launched Complify, a complete game changer whose algorithm predicts what laws and compliances apply to a business with just basic details. So what would earlier have taken hundreds of hours and exorbitant professional fees can now be achieved in just a few minutes for a small monthly subscription. So go conquer the world while we worry about your compliances. We are Lexplosion, the legal innovators.
Now that your compliance house is in order, it is time to focus on managing your endless stream of contracts.
Meet Jyoti, contract executive with a global conglomerate. She is conscientious and brilliant, yet she is struggling to keep pace with the drafting, negotiation, and abstraction work hitting her inbox. And finding an executed agreement is a nightmare. First, searching through hundreds of her folders, and then those of her colleagues from the shared drive. Before she knows, the day is gone. The business folks are mad, as is her boss. Enter Comtract, Lexplosion's contract solution. At the click of a button, you can upload those hundreds of folders containing different categories of contracts, sync them to your obligation trackers, create milestone-driven tasks and alerts, get sliced and diced reports of your rights and duties, and you will never again have an agreement expire without you getting an alert well ahead of time. Suddenly, Jyoti's days are structured, and she is once again able to focus on her contracting skills. Backlogs reduce by over 80% in the first 3 months and almost disappear over time. The business is happy and coming to work is a joy again.
With compliances under control and contracts managed, it is time to focus on your never-ending disputes.
Do you spend sleepless nights worrying about adverse ex-parte orders because your counsel did not appear in court? Are you losing control over innumerable matters pending in different courts and tribunals? Do you worry about your litigation spend going through the roof? We have a solution for you, and it's called Comlet, a dispute management software which provides efficient tracking of cases, dates, forums, and lawyers. It auto-generates list of dates, allows one-click upload of all your existing litigation data, and syncs them with your trackers, apart from providing a wide array of reports ranging from case status to contingent liability to budgeting and billing information. With Comlet, managing litigation has become a lot easier than avoiding them.
And if you thought you have heard it all about Lexplosion, think again. Because we complement our products with high-quality services, ranging from compliance consulting, training on various aspects of law, drafting contracts playbooks, and building contracts and litigation trackers. For more on Lexplosion, do visit our website www.lexplosion.in.
A very good afternoon, ladies and gentlemen. Many of you have made a huge effort to join us today, and we definitely want to thank you. Thank you very much for joining us today. I'll quickly introduce myself. I'm Kanishka. I am a business development manager at Lexplosion, working here for the last 2 years, and it's definitely a pleasure hosting all of you today. To start things off, we would, definitely start things off with our keynote speaker. Our keynote speaker is Mr. Pramod Rao. I would, request everybody to join me in welcoming him on the stage. Mr. Rao is a general counsel at the ICICI Bank, and he is in charge of the legal function of the ICICI Group from August 16, 2018. Please welcome.
Thank you so much. With the kind of overview which we've got of Lexplosion, I don't know whether half my thunder is already gone. But nonetheless, with what I had spoken with Indraneel, I will at least try and outline what I see as both the interplay of law, technology, and especially the implications on the legal function in-house. I know we have a wide array of topics that the panels will be discussing, including data protection, specific compliance tasks, implication of adopting technology solutions, and so on. So I will not try and preempt them. What I will want to talk about is really how I see the law tech space evolving, how I see some of these interplays at close quarters. And probably the implications for both the organization that we are part of, but also the wider community. I think the key to great in-house legal teams and their effectiveness is really about data. It is about how data is captured, how it's organized, how it is applied. It comes down to frequent reviews. It comes down to recalibration of approaches, whether on documents, products, processes, and of course people. To me, the fact that data can be organized, gathered, organized, and mined is, I think, the biggest boon that technology gives us. And to me, that, I think, has to be the fundamental starting point for any organization looking at embracing technology, or for that matter, harnessing it as it goes forward. To me, for instance, litigation data, and I realize that Lexplosion has this Comlet as a software. To me, it permits really identifying hotspots of issues. It allows us to look at what are the product features or what are the process flaws which contributed to litigations actually arising. It looks at and gives us opportunity to go back and plug those product flaws, or for that matter, process gaps. Equally, it is a data for about how you incentivize or disincentivize really your customer behavior. To me, all of that comes from that data which can be organized and which can be harnessed. On how it feeds into the books of accounts, again, to those of us from the litigation domain in companies, clearly being able to classify the cases, whether into probable, possible, remote, feeds directly into the books of accounts in terms of the provisions you hold because it's probable, contingent liability because it's possible, and remote indeed not featuring anywhere at all. But to me, it is today's boardroom and the audit committees which actually demand all of these and demand, in a way, accountability of that your past predictions are indeed borne out. So at some level, the accuracy of the data, the way it is projected, the way it is both displayed and for that matter mined, gives that comfort of whether indeed your litigation management is really on track or not. And to me, again, without technology, I don't think we can be anywhere close to harnessing all of these issues. Equally, what litigation management software permits is really tracking the progress of cases in the courtrooms, deciding whether to choose to appeal or comply, and equally, therefore, looking at how you would like to engage with your external counsels in the brief and the instructions that you're giving them. Moving towards, which again, as I said, I think Lexplosion has virtually got all of the product suite one would expect. To me, controlling contracts that a business enterprise enters on a day-to-day basis, whether it's sales, services, property-related, or lending contracts in our case, to ensure uniformity in the calls that are taken, to ensure that the risks which are assumed or which are allocated is indeed on the right track. I think, again, a contract management software is essential. To me, how it then sort of allows us to track both respective rights, obligations. I heard the video even talk about, when it's coming up for renewal and so on, but equally to my mind to then decide how you want to enforce these. So all of it, I think, really feeds from having great contract management software, but equally a repository of all the contracts that indeed one enters into. Going forward, I would say monitoring compliance. And truly, I guess that's the heart and soul of Lexplosion. The ability to know what is the legal obligation, what is it that is the regulatory obligation. Being reminded, being prompted to do those compliances, to have them reported, or being alerted when they actually have not been. I think, again, can provide either a whole host of comfort to the board, to the senior management, or for that matter, where they need to actually intervene and sort of get things moving. To me, the knowledge in mapping the laws to the type of business activity and the business activities is not to be taken lightly at all. To me, whether it's the type of business entity, whether it's the type of activity you carry on, the geography where you carry on, all of that can really make an implication around it. To me, one of the things which always startles, even as I recall it now, is as a banking lawyer, as a banking in-house counsel, I never thought I had to ever know Weights and Measures Act, right? Yes, we did probably touch upon it when we were at law school. There's a legal metrology department which we know exists around the states. Some of the manufacturers are smiling, and I can understand, yes, it is your bread and butter. But to me, when suddenly we at a bank, at the bank that I was at, decided to sell gold coins, suddenly this Weights and Measures Act became very, very relevant to us. And my business counterparts actually asked, here's a titan which sells gold coins. Here are gold retailers across the country who sell gold coins. So how come this is something we need to comply with? Well, guess what? For us, the very fact that it was going to be packaged, it was part of the assurance that we were giving to our customers to say that this is the purity and this is the weight of it and so on, and that it was packaged, meant indeed that we had to comply with the Weights and Measures Act and the rules on packaging. As a banking lawyer, I would tell you it was never something which we would have thought about, but clearly immediately impacted our product rollout, impacted our packaging, our retailing, and so on. And the worst of it was really the fact that one has to specify MRP. How do you specify MRP on a product or a commodity whose prices vary day per day? So we had to actually say, okay, you know what we will do is put 3 times the MRP, right, of what we expect, because the volatility in the gold prices is not something we can predict. And yes, every 6 months we will sticker over the MRP, because if the prices have indeed moved, we need to be making sure that we are not either mis-selling or selling at a lower price than it is intended. So indeed, as I said, it comes down to mapping out the type of business activity, type of business enterprise that you are, and really thinking about compliance of laws with that in context. To me, I think law tech has the ability to be what I would call a force multiplier. So, it's not necessarily about creating redundancies or acquiring lesser number of people. It is about how to engage people with the ability to track, how to have ability to analyze, how to be able to enforce, or for that matter, extract the best outcomes on an incrementally consistent basis. And to me, that's the promise which I believe law tech holds. It allows one, therefore, to fine-tune responses, revisit, recast, if you will, the contractual terms. To me, that freeing up of the mind space of the teams one has to be able to add value on an everyday basis to an enterprise is the dramatic positive consequence which one looks forward to. I'd like to, in fact, illustrate the power of both data being organized, law tech, and its ability to impact both commerce and community. One of the exercises we ended up doing at ICICI was, and this goes back some 8 years, 10 years, we organized all of our litigation data across the country into types of cases and so on. And one of the things which allowed us to suddenly realize was that in Kolkata, Indranil's hometown and Lexplosion's home office, is one place, is one city where we had more number of insolvency petitions than any other part of the country, any other city, any other state. And looking at the data, it just made us feel that there was something going wrong there. And indeed, as we probed deeper, it became clear that there was an organized racket, which was actually soliciting defaulters and defaulting borrowers to say that, your creditors will not come and touch you anymore, will not disturb you anymore, will not call or file recovery if you file an insolvency petition. Clearly ill-advised. There are lots of consequences of insolvency law, and we still are expecting the new IBC to roll out to individuals. But this concerned really individuals, and they were not even aware of what they were doing, and they went ahead and filed these insolvency petitions. With this data, we both talked to our counterparty banks. We found that they had a similar epidemic, and we all jointly approached the Calcutta High Court. Result was that it ordered a police inquiry. Consequent to that, the official assignee was actually suspended and relieved of his duties. And it resulted in several arrests and so on. But finally, from our viewpoint, also the disposal of all those insolvency petitions. Right? And why I illustrate this is I look at it as the ability to look through data, look at the anomalies, and being able to then decide what's the course of action one wants to adopt. To me, closer home and closer to time now is what I would call even more interesting and innovative application of law tech. It is actually data arising from motor vehicle accidents. And within our group, we have a general insurance company, ICICI Lombard. And to me, what they described was, we as an insurer get both motor vehicle accident claims. There is a compulsory, forum where all these claims have to be litigated. It's the MACT. But along with that, what they get is 3 sets of data. They get the police reports, they get the hospital records, and obviously the claim in terms of the financial income and so on of the person who's got injured or died in the accident. Looking at all this data actually allowed them to put together a list of hotspots, or I think they use the term of calling it black spots around the country, right? These were the high accident prone zones. These were where the accidents were really happening. And they went ahead and surveyed these areas. They figured out what was the challenge. They took this data right to the Ministry of Roads and Surface Transportation. They took it to the state level authorities and the municipal level authorities. And what it allowed then was really these roads being actually fixed, the accident prone zones being addressed. And to me, the results are threefold, right? There's safer roads, there's improved safety of the people or the health of those who are traveling using these roads. And truly, from a financial viewpoint, you can look at it as reduced claims to us as an insurer, right? But to me, this comes back to the power of data to really, and law tech in a real sense, because we were looking at not anything which was private data. We were looking at claims filed with us, we were looking at MACT records, and we were able to piece together what really were the black spots around the country. To me, all of this equally leads me to believe that there is far more richer ability to both influence the society and influence our own organizations into taking right steps. If I had to switch gears and talk about a real game changer which I saw happen in the retail banking industry, it's been really the creation of credit information bureaus. Its creation actually preceded the law in some senses. We had the first bureau which came up as a joint venture of Dun & Bradstreet and HDFC. And sooner than later, it became a utility amongst all of us banks. And what it did was this. It aggregated all the defaulters' data into that bureau. So what we were doing thereafter was really pinging that database to see, okay, is a new applicant somebody who's already defaulted to somebody else? And it allowed us, therefore, to make sure that we were not really going to give money to somebody who had defaulted, or we would certainly charge a higher price than probably what we would have charged had we not had a default noted at all. To me, thereafter came the law, which was the Credit Information Companies Act. It came because of 5 years of the Credit Information Bureaus working, us understanding all of the pitfalls or the issues and so on. But it also allowed thereafter co-opting of utility payment data. So suddenly we had both NBFCs, we had banks, we had utility payments, and all of it allows really a knowledge of how the credit profile of a person is. We have engines which can actually predict basis the past behavior to say how the future behavior will be. And truly, again, retail credit, when it is booming in the country, it's being driven by such an engine. How I make it adjunct to law tech is really that the first 5 years was contractual. It was just about us taking a contractual right to pool in this data and share this data with the Bureau. Post the legislation, post the Credit Information Companies Act coming in, it was obviously a statutory obligation to be actually able to pool that data and have to do it. The framework, even as we evolve, the question which I would have for everyone is really to say what else, what other pieces of data are there around the country. Talked about the MACT, I talked about the credit information and so on. But what else is out there which if pooled, which if analyzed, which if aggregated and put to use, can really make a difference to the community and to the society? To me, the framework, and I'm sure the panel on data protection and privacy is going to talk about it, is what is it that we as in-house, what is it that we as lawyers will play the role in writing those contracts, both in terms of pooling, what is not even anticipated right now, right? I think I would be remiss if I didn't add the value of tech in really addressing and aiding the issues around diversity and inclusion. To me, software and equally all of the platforms and all of the products that Lexplosion has, or for that matter, any other offering, should really be able to cater to making sure that those with disabilities can equally harness these. So whether it comes down to people with visual impairment, blindness, to me, just making sure that indeed either your software has the ability to be able to be read aloud by a software, to have tactile sensations when really they are using or accessing that data or the software, or for that matter being able to have voice responsiveness or being available on a mobile. All of these, I think, are really the need of what I would say the diversity and inclusion that we at the corporate sector would equally like to foster. To me, the role of players such as Lexplosion would really be to say that is your software already enabled to that? Because that then allows us to really plug and play even as we go and find people with disabilities. I made the mention of tech solutions having to be on the mobile phones and probably on the iPads. I think it speaks to, and I was telling Indranil just before this session started, about how actually we realized that some of our litigation updates were actually lagging behind time for the reason that our lawyers were in the courtrooms. And for them to come back, we would probably lose a day, we would lose the actual context of what went on in the courtroom. And lo and behold, we have created an app which is for lawyers on the go. To update these things as they are leaving the courtroom, right? So we really are not losing time. And so to me, again, how much of the software can be on the mobile, how much of it can really be harnessed in real time is equally what I would tend to say that tech has to really cater to. Moving on, I think compliance of all laws applicable to an enterprise, especially in a country like India, with the multiple level of lawmakers that we have, federal, state, municipal, it can seem very daunting to every law-abiding business, be it multinational companies, business houses, or first-generation entrepreneurs. To my mind, Lexplosion has indeed set out in the journey of making compliance easy to track and do. The complement of products and services that we saw is laudable. I really compliment the team for what they have gotten to. Given it's their 10th anniversary and harking to the remarks that, Indranil made about what was in 2007, well, the way I would say is that, well, given that law tech is still in an emergence phase and nascent phase in that sense, think of yourself as IBM, right? So you are probably the IBM of law tech. And yes, of course, there were later players. There's a Microsoft which came along, there's a Apple, there's a Google, and what have you. But, the way I would look at it is IBM had a 70-year run before the next player came along which challenged their dominance. To me, the way for you is indeed to be watchful, to be alert, to be agile. The needs of the community, needs of the corporations will indeed keep evolving, as does the society. And with that, I will just say that I'm looking forward to hearing all of the panels and the debates. So thank you very much.
Thank you very much, Mr. Rao. And it was definitely very interesting, all the experiences that he shared and his insights about how technology can help, manage data and how organized data can help a company. So definitely warm thank you to you from all of Lexplosion. We have a very interesting session coming up, and our first session is about the most talked about bill, in the country right now. It's about the Personal Data Protection Bill and the anticipated challenges and hurdles from an industry perspective. So our panelist, we have a house full of panelists for that, and our panelist will discuss the issues and the challenges that companies are likely to face once the bill is enacted, and also how they are preparing for it. And, to moderate, I would request Mr. Indranil Chaudhary to please come on stage.
I request my other panelists to join me on the podium, please. Can I have Aditya? Ayan, I'm not sure if he's arrived yet. Ayan Rai Chaudhary, are you here? I don't think I've seen him yet. Purnima and Shantanu. And I'm hoping that eventually Ayan will join us as well. Hi, thank you for joining. Good, likewise, please. Okay, so this is again a mini reunion of Hindustan Unilever, because as I realize, Aditya, of course, is still there with HUL. He's a tech junkie, and also currently the data protection officer for HUL. He's been working for HUL for the last 10 years in a variety of operational and strategic roles. We then have Purnima. Purnima is the Vice President Legal at Tata Sons. She has a cumulative experience of over 15 years and a corporate lawyer who's also admitted to practice law in England and Wales, as well as in New York. We have Shantanu, who's the head of regulatory compliance and governance in Mahindra & Mahindra. And prior to this, he has worked as an in-house counsel with HUL for 20 years, both in India and Nepal. So that's really the panel for the moment, and we will hopefully sooner rather than later. I last heard about half an hour ago, Ayan was in Worli, but this is Mumbai, where like I was telling somebody just before this, that barring the occasional falling of bridges, we mostly reach, between any 2 points in Calcutta in about half an hour's time. In Bombay, that's probably what it takes you to reach your neighbors. But, this is an interesting topic in many ways. Data protection bill is something that is obviously ripe for discussion at this moment, especially for the industry, because there are comments being sought for by the government on the bill that has been now tabled by the Sri Krishna Committee. And therefore, if we can, as a group, think of things that we can talk to the government about, that would be fantastic. But apart from that, I think a lot of the public discourse that has happened around data protection till now is really around civil rights, liberties, privacy. But there are the practical realities of operationalizing this whole data protection bill in the way it's been presented, while every aspect of it is hugely laudable and I think is something that we all should be very proud of, considering that we have managed to live with just the SPDI rules for the last close to a decade. But on the other hand, there will be serious challenges. When GDPR was first announced, I think the European Union was already extremely sensitive to privacy and data protection, and even the previous era of data protection laws that were present in most of the European Union were extremely stringent and required very serious processes. Whereas if you look at most Indian businesses, I'm not necessarily talking about the large businesses which are represented here, but a lot of the businesses down the line, the current status with regard to many of them is that they haven't even got their ISO or IC 27001 basic audits done. So that's the reality of India. So to operationalize and implement data protection bill is unlikely to be as smooth sailing as GDPR was. So it is in this context that I thought that we should speak to the industry. Obviously, we have three companies being represented here, but I would request everybody else, of course, Pramod and all his colleagues from the banking sector, we have people from the pharma industry here. So it's something that impacts all of us, obviously. So I will pose a few questions to the panel, but then I'll open up the discussion for the larger audience for a generic get an idea of how we can take this discussion forward. So that's essentially the purpose of this. And I have some questions. I will start by asking them, and I will hope that as we move on, it will open up more areas of discussion which can include everybody else. So to start with, and Purnima, if I can start with you, we had a brief discussion a few days back. As an organization, I'm sure the entire Tata Group has been hugely sensitive to the Information Technology Act. By virtue of your huge presence in the European Union, I'm sure you've already you've already invested a lot of time and effort and of course money into complying with GDPR. When you see the data protection bill, what do you really see? Is it really a continuation of what we have seen in the GDPR, or is this going to be significantly different from what we have experienced with the IT Act and GDPR?
I think 70% there is a 70 to 80% commonality between the GDPR and the Indian bill. And so far, many Indian companies, at least within our group, we've been comfortable, other than the obvious ones in the EU, like say a Jaguar Land Rover or a Tata Global Beverages, many companies have been quite comfortable saying, it is the GDPR. We're not entirely certain if it really applies to us. There's a lot of investment required to make sure, we start complying. And I think the good part of the Indian bill is everybody's had to sit up and say, we no longer can defer compliance. We no longer can take data privacy that easily. The other change, and I think that's really a coincidence for the Tata Group, is our new chairman is the former chairman from TCS. Right. And I think what he brings to the Tata Group is remarkable in terms of technology. Many companies in the conglomerate have been used to doing business in a certain way, which are probably structurally and process-wise very different from TCS. TCS in every which way today is a global company. I would put them on par with, say, a Google or an Apple or an IBM or a Cisco. Maybe the other Tata companies have not had that sort of nurturing, and that's changed. So what we have today is a chief digital officer and who comes from TCS. She's a digital transformation head. And the beauty of that within the Tata Group is every single project that goes on. So let's say it could be, the presentations we saw on compliance management, litigation management, data protection, contract management is a really good collaboration between legal and digital. And I find that useful for data privacy as well. So, to give you an example, something like data localization. The group took a view. The digital IT people took a view that all Tata data must be stored on Indian servers. And this was taken a long time ago at TCS, sort of transferred to the rest of the Tata companies. And so when I saw the bill, it was a chunk of my problem already solved. And if I had tied up quickly with, say, the Thomson Reuters of the world, or say, for instance, a Wolters Kluwer's who offer competing services, I would be in trouble because the data is stored on their servers or their cloud and then mapped onto my servers. And again, getting back to data privacy, these projects are being done with digital and legal, and I find that helpful. It's very easy for me to say, give people an option to unsubscribe. But how do you do it? How do I make sure back end somebody has actually done that? That is done with IT and digital.
Right. So I think that brings us to an interesting, corollary, Aditya, if you can take that. I think more than anything else, more than the aspect of a new law, it's about the new processes that will now have to be laid for almost every aspect of a business, like, say, a Hindustan Unilever, which is so customer focused, so B2C in every aspect. You must be gathering terabytes of data from hundreds and thousands of people on a daily basis. To say that they will now have to be given the right to informed consent, to have the right to be forgotten, to have data localization for all of them. That's a serious amount of process reorganization that I can think of as an outsider. You, as the data protection officer from HUL, must be already, deeply involved and trying to get to the bottom of that. What kind of thoughts are you bringing in terms of, is this something that you've already done with GDPR and therefore is just a simple laying down of processes for you?
So, Indranil, I think GDPR is probably one of the most recent events that have happened, which has significance, such large significance for a company like ours. However, this is definitely not the first one. We are seeing trends where consumers are becoming more aware. We've had a care line for eons, and we started seeing queries around personal data coming in the last few years. From
India?
Yeah, from India, within India. In fact, we've queries in the sense, what data do you have and, what are you doing with it? Because I received a call from one of your, brand representatives, etc. And these kind of calls have been going on. We've had the AP Shah report, now with the B.N. Sri Krishna report. Of course, the Supreme Court judgment in the Puttaswamy case. So I think all the, the signs were already there for a very long time. It's not something that, just happened on the 27th of July that we suddenly woke up and realized that we have these massive, compliances. And at Unilever, being a European company again, and they've got this jurisprudence since 1985, they've been thinking about privacy, individual privacy since all the way back then. A lot of these systems were kind of part of the culture that existed. Looking at data not as a piece of property, but something that we hold in trust is something that I think I'm very happy to see that it's been reflecting in the bill, but it was something that we used to consider at a long time. So I think the bill itself was expected. Of course, like Purnima mentioned, there are some deviations from GDPR which will create some level of complications, but overall I think we were ready for it. Coming to your second question with regard to the technology. So most of these things in some way or the other already existed. So for example, if I look at data protection, principle, I have to change my vocabulary, principle.
That's probably one of the most positive changes that have happened in the bill, the use of the terms fiduciary and principle.
Principle, right.
As opposed to subject,
No longer subject and controller. That's why, the vocabulary has to change. But I'm saying the data principles rights, I mentioned the calls that we've got, and then, trying to assimilate data in one source so that we can actually answer such calls. Tata chose to keep them in-house in India, localized. We chose other options. We want to leverage global resources. So we have been in some way on that journey as far as the technology is concerned. But yes, we have challenges now. The new bill poses very strict notice requirements. So, if any of you are familiar with the kind of home-to-home marketing that we do, I can just imagine, a person working on minimum wage who goes to home trying to explain to a consumer as to what rights they have and where they can obtain a copy of the data, and the list of objects that have been given, the items given in section 8. That will be a challenge. We'll have to find how we can actually, not necessarily technology, but we'll have to find ways as to how we can get that notice across.
And also to then be able to be sure that the notice has been received with the right requisite amount of information for it to be considered informed consent.
Absolutely, and the burden of proof lies on us.
Absolutely.
So that definitely does complicate things, and the need for technology comes in over there.
You mentioned, Indranee, something, the right to be forgotten. It's a little different between the Indian bill and the GDPR. So, and I think thankfully it's easier, at least from a corporate perspective, when somebody says, I need the right to be forgotten. Companies like ours are not in the business of really, it's not a business to manage data. It's a means to get to an end. And when you say, the right to be forgotten has got to be really linked with, I would say, a broader record retention policy, right? And it could not just for personal data or sensitive personal data, but for a lot of data that companies have. A lot of us aren't yet sophisticated enough to have formal record retention policies. And I'm, in a way, from a company perspective, I'm actually glad that the onus is on the person requesting he or she has to write an email explaining, let me know if the purpose is relevant or not. Let me know if you've exhausted all, is it incidentally relevant? The onus is on the person who's requesting, not really on the company. From a civil liberties perspective, maybe I'm off, but being in-house this makes our job a little easier. And I would put it on the roadmap.
Yes.
I would say 2019, maybe even 2020, we need to get a lot more sophisticated to deal with these issues.
Right.
But right now, I would not prioritize it.
Yeah, as a matter of fact, with the right to be forgotten, the subtle difference is that in India, at least what is mentioned in the bill as of now is that you can apply to the adjudicating authority without necessarily, you can't really come to the company directly and ask to be forgotten, which definitely, to your point, is a little less painful from a corporate perspective. I will want to bring in.
No, just to add to that, sorry. So on right to be forgotten, so it's not that you delete it immediately after that. So only the sending of further communication stops.
Right. And also from your perspective, Shantanu, because you work through a lot of third parties, dealers, people who are really not directly in your control, but they will in many ways be the people who will be what will probably be termed data processors within the meaning of the new data protection bill. I'm sure you already have contractual and other serious processes in place to handle the data that they collect from all of us customers of Mahindra, including me. But my question to you is, do you see the data protection bill requiring you to deal with these third parties differently from the way that you're dealing with them now?
Let me, answer in a slightly different manner. So the challenge which I see being posed by this law is that we will have to take measures at the technological level as well as at the people level, because despite the best technologies I personally believe that today through technology we can achieve anything. We want to achieve an end result, our engineers would figure out and create the appropriate algorithms and software to do so. But then when the human element comes in, and particularly for a company of our size, where we deal or we have more than 200,000 employees, and I am assuming out of this a few thousands, maybe 5 or 10,000 would have access to personal data. So now how do you ensure that they exhibit the right behavior at work? So that is going to be a challenge. We'll have to, think of constant training for these people, and as well as some mechanism of, getting periodical assurances, maybe create SOPs, and when, the teams which are developing say newer technologies or newer processes. So the interaction with the legal has to be constant, and I would say of a much more higher order, increased order, intensive.
Now, training is a very important point that you bring in, because I don't think, I'm hoping almost an entirely Indian audience here, so I can say with some amount of humility that we are probably not the most sensitive to privacy and data protection when we have tried to deal with these discussions. So we do Information Technology Act related audits for some of the companies. So when we have brought up issues which are quite obviously breaches of sensitive personal data and information, it has almost been dealt with contempt. How can you even expect us to do these things? We have to collect hundreds and thousands of vendor-related information on their banking data and financial data. You suddenly can't say that I'll have to dispose of them whenever every employee leaves or a vendor goes away within a certain time, just because some IT Act says it, because it's not the way our business is done. How do you people deal with that? And you're dealing with obviously hundreds and thousands of people. So Aditya, you have a mic, and Purnima, you have
just to add to what Shantanu was saying, and that leads up to your question as well. You see, the bill poses absolute liability kind of situation on us as far as the actions of our contractors or our service providers are concerned under Section 11, and there are criminal penalties also that have been, massive fines, etc. And in that kind of liability, read with the kind of culture you're talking about, where it's not just consumers, even people we deal with, who don't appreciate individual privacy, we are looking at a very massive risk over here. We are looking at potential jail time for offenses that we have absolutely no control over, or we had absolutely nothing to do with the commission of.
More than jail time, a company like yours is also potentially looking at 4% of your global revenue being put at risk by virtue of.
I'm very hopeful that we're not classified as a significant data fiduciary. That's another point.
That's what you think. You still might be.
But that's definitely something that we're ambiguous on. So I think it really needs a difference in a change in culture. There has to be some processor liability brought into it. The way the bill reads right now, we are absolutely liable for any actions that happen. The UK Bribery Act actually provides for a adequate measures kind of regime, where if you have taken adequate measures to ensure that this offence does not occur, then leeway is given to, or some sort of preferential treatment is given. So I think something like that, where we can take all the reasonable steps to ensure that such an offence does not commit, and if due to human error or due to any sort of malice it's conducted, that's a different situation.
Purnima, I'll come to you in a second, but for example, the sensitive SPDI rules very specifically said that the ISO ISC 27001 audit and certification and annual review will provide you with certain amount of safe harbor if there was a breach. There is no such, at least in my limited reading of the data protection bill, such clarity in terms of safe harbor, which adds to your risk. Sorry, and I'll move to you, Purnima, now. On the same issue of how do you plan, because Tata's again massive, and barring TCS as you mentioned, it's how do you plan to deal with this?
So I think third-party vendor management is an issue not just for data privacy. It's an issue for corruption. It's an issue for ethics. It's a compliance related. Something as basic as, when senior executives join a company, HR will engage somebody to do a background check. Most companies in India that do background checks actually record conversations. They record, they store, they keep, they'll probably keep it in their repository for a 6 to 8 year period. An HR standard response across most Indian companies would be, I've just outsourced it. So so the third party vendor issue is not specific to data privacy. But that said, I actually think for certain traditional companies, it's a great in to go in there and say, listen, the law requires us to do this. So let me create a platform whereby every single third-party vendor above a certain threshold, right? I mean, you get a roadmap. Let's say in 2019, I figure out a business that we do above 5 crores with any third-party vendor. And as time goes by, you bring the others into that network. But you have a platform with all third-party vendors. And what does it allow me to do? Let's say I start as a pilot for just Tata Sons. It allows me to check legal, HR, for basic facilities management, 3-4 other areas. And let's say for a company like steel, it is a massive project. But what it's facilitating is onboarding every third-party vendor onto a digital platform in the name of data privacy. But at the end of 2 years, the data that I'm going to have is spectacular. I'm going to actually have a lot of other data on, I could introduce KYC norms for them and use this privacy as an excuse to move to other areas.
Only thing is that that data will get covered by the data protection bill as well, of course.
It will, but it will also make sure over a period an organization is more ethical and clean. And I think a lot of younger lawyers who've been working with older companies have been looking for these sort of excuses to swoop in and say, listen, look at third-party vendors as well.
So, welcome. We have our fourth panelist, and thank you. I know that we'll have to kind of pull you into the conversation, and I'll try and do it as well as I can, Ayan. And we've been discussing about the various potential aspects of data protection. Ayan is from Sony Pictures and heads legal for them. So, again, has very unique perspective to this. I think all the others were largely from a FMCG manufacturing background, and Ayan comes from a slightly different background to that. And as Sony Pictures, as somebody who I'm sure is likely to be considered as dealing with fairly significant amounts of children-related data, for example, because you will be running channels and running programs which are probably to a certain extent dealing with children. How do you view this change that the data protection bill is likely to bring in?
The legislation, what I have read till now, and compared to the GDPR rules, the implementation will be a challenge. It's not that as if even today we are not, the accumulation of the data, the storage of the data, and how to deal with data is something that we are not dealing with. We are dealing with it. The problem is with certain terms or terminology which has been used in the legislation. And how do we deal with those in terms of implementation? As far as children data is concerned, yes, it's always that we take the consent of the adult because they are not contracting parties. We store it. Yes, we store it here. Do we transfer it to somebody else? We don't transfer it to anybody. So as far as the provision in the law is concerned, that you are not supposed to be transferring it to anyone, you will not be trading in the data. That is what we anyway compliant with. But I believe it goes beyond that. The other penalties, the other issues, and the terminologies which are being used in the Act might become problematic if this is what will become the law. That is my take on it as of now.
That brings me to a point, and I'll start with Shantanu and I'll move around the panel. Now is the time to establish that we are not fully happy with everything that has been mentioned in the data protection bill. So as people who are dealing with this, have you thought of what will be your, say, top 2 key pushbacks on this data protection bills? Or let me turn this around. If you had the option of changing 2 things about the data protection bill, what would those 2 be?
Clearly, first thing that I would say is about the quantum of penalties, because I believe in India till now is not at a stage where we can start operating with a fear of a penalty of that magnitude. Even though the law says that all the provisions would kick in after 18 months from the date the DPA is notified, but considering that for GDPR in a European environment they had to give 2 years, in India I believe that would be the requirement would be far more. And the other thing that I would say is regarding these consent requirements that need to be simplified. the kind of elaborate notice that is required as per this law can only be possible when you are collecting through electronic means. Now, in India, there are a lot of businesses. Say, for example, you step into a mall and the first, person who greets you, there is a suited gentleman with a coupon. He will tell you that there is a lucky draw and you have to share your details. That doesn't, contain even the name of the entity who is collecting it.
That would clearly have to change if this current version of the law.
And there are many businesses which probably, cannot afford, even in today's times, elaborate IT infrastructure to collect data.
Sure.
So they would completely go out of business.
And which, I don't know whether Gautam Roydekar is here yet. He's one of our panelists in one of the later sessions. He is the General Counsel of Raymond. And I wanted to specifically point out that, biometric information now includes measurements that are taken from people. So, which essentially means that every time you walk into that the fancy Raymond store and give your measurements, you are actually providing them with sensitive personal data information, because biometric data is SPDI, and that's completely new in the context. So even your measurements that you're give to a tailor will now have to be protected as SPDI, not just personal data. Sorry, I'll move to
just one thing, Indranil. I mean, my reading of this law, the way the language of it, it is so cumbersome. It is so concerned. Who in our normal legal fraternity uses the term fiduciary so often? I mean, I can understand an individual and the person controlling the data. Data fiduciary? I mean, God forsaken, what's that term?
I guess I guess if I had to think of it from a lot of art. So we obviously wear two hats. One is the industry hat. The other is the individual or the civil society hat. The civil society version of this is that this is probably one of the best things that the law has done, because it clearly lays down that there is no data subject. You have a data principal who's actually the owner of the data, and they give the data to custodians to deal with it like they would if they had fiduciary responsibilities under law. And therefore, I think the term. So I'm not justifying it. I had nothing to do with the writing of the bill, but I think that's the context. I completely get your frustration.
In GDPR, it is simple. It is simple. It is the individual, subject, and the collector.
Right.
Here it is fiduciary. I mean, God forsaken, who uses that term in the normal legal fraternity unless a judge is delivering a judgment or something. Now, coming to the various other positions, yes, I completely agree with Shantanu about consent of collection of data, and then the entire elaborate procedure. We are talking here of 71% of the rural population also. I mean, are you going to give this detailed list in the local languages of the different states?
Which is required, actually. Yes.
So, I mean, are they going to understand it and what it means? And you are collecting data all the time at various points of your interaction in life.
And how will you even know whether at the end of it the consent is informed or not?
Correct.
In a situation like the rural India that you're talking about?
Yeah.
Yeah. So Purnima, you had a point.
Sorry.
The question really, I didn't quite understand. What is objectionable with the use of the word fiduciary?
No, my objection is not with the use of the word fiduciary. The point that I'm trying to make is that if the linguist, the tone of the legislation itself is so heavy, the requirement of the consent and the details of it is so heavy, why can't we as India, as a country, yes, this is very important law, I understand it, but if you have to get it interpreted before a court, or even if it is a special tribunal, it is so heavy in terms of the language. Make it simple. Anybody collecting data will have to go by certain things. Anybody whose data is being used have to do certain things. I'm of that, not term person.
Fair enough, but when I first saw this and I read the word fiduciary, I was actually taken aback, because what it told me was the data belongs, date of birth, date of anniversary, other personal, Aadhaar, bank details. The data belongs to somebody. And if I as a company collect that data, I hold that data in trust. And therefore, as a company, I owe some duties under law to protect it. Whereas under the GDPR, it was a lot about data collection. The thought process was actually similar. It started out, the case was interesting. There was I think a former Google employee, somewhere lost his job. He went through insolvency proceedings, went and applied for a job in Spain. He could not get a job for a 2-year period because everybody would pull up his old records and Google searches would show he'd been through a difficult time 2 years ago. He filed a case and the response to that, in addition to Google actually paying, was the GDPR. India then woke up. We've been talking about privacy for a long time, but India finally woke up, saw the GDPR, and we adopted a lot of it, but we forgot the right to be forgotten, which was the origin. But what I thought India actually did in a very elegant way was actually tell companies, you're holding this data in trust. We use the word fiduciary for directors, right? You owe duty of care, duty of loyalty, duty to protect. And I thought this creates a different language, so to speak.
Since you already have the microphone, and if you can also tell us if there were 2 things that you would want changed with this current version, what would they be?
I'll tell you one thing I'd like changed. If there is a data breach, the bill doesn't require a company to notify its customers. So I'm not aware at the moment whether it differs for the BFSI sector or the financial services sector. I'm not aware. But I know for most of our Tata companies, we don't have to notify the customer. You need to notify your internal officer, who in turn will let a adjudicating authority know. That's problematic. I actually feel it would put tremendous pressure on marketing departments, HR departments, customer relations, if it was a PR issue, because there's been a violation, data violation. So for instance, when Yahoo was on sale and Verizon bought Yahoo, it was during their due diligence that they found out that a year and a half prior, about 30 million accounts had been hacked into. Yahoo did not share that, even though it was a listed company, because they were at that time probably not required. Or for instance, Uber, when Uber was when I think SoftBank was putting money into Uber, they found out during the due diligence that X million accounts had been hacked into and credit card data had been obtained. It actually impacted negatively Uber's valuation. But Uber did not make this publicly known. People found out much later. So I think that should change.
Okay, so that's an interesting one. Aditya, you're still not given us yours.
So I think the grounds of processing that have been mentioned in the bill are inadequate, and there are many more grounds that, if you just introspect and see on an everyday basis the kind of data that a company processes. I mean, something as simple as our reception, right, where people come, we issue them a visitor's pass, we take a picture, and we take some contact details. Those are not strictly permissible unless you have all those notice and consent requirements met. So while there has been
unless they're coming in for an interview,
which is an employment, which would be a part of employment. And I think employment is just one part of the data that we process. I mean, I can tell you so many instances where we do. Then sensitive personal data, again, ground of processing. There is no employment exception also for sensitive personal data. We have an occupational health center. We give salaries, etc., etc. So sensitive personal data there is not covered. That's as far as the grounds of processing are concerned. Another thing I would like to change is the accountability provision, which places, like I mentioned, an absolute liability on the data fiduciary as regards the processing by its third parties. In the modern day world where we have principal to principal arrangements with our processors, it's very difficult to actually sort of ensure that they work in strict compliance. So I think these are the 2 things that come to my mind. Of course, we are preparing a representation which has many more items, some of which have been covered. And, so there are quite a few things that we would like to change there.
Okay. Okay, so my colleague there has been given the onerous task of keeping us reminded of time. We have roughly about 8 to 10 minutes. In the interest of, we have, we have Pramod, we have Honesh, we have, Trivikram, we have colleagues from so many different industries, and data protection is something that, We have Siddharth there. Ganesh, if there's anybody else who has a thought on this whole aspect, a question for the panelists, I'd like to open up the discussion to the larger audience and expect some feedback, for example, from pharma, from banking, on how you're planning to deal with this new animal, which is not necessarily a bad animal, but still a slightly wildish animal which needs to be probably tamed a little bit. So I'd open up the floor for some questions and some thoughts on what you would want to know about the data protection bill.
I'll just take the opportunity of actually agreeing with Ayan. I think the entire concept of saying you are a fiduciary, I think the reason we are commercial organizations is we enter into commercial arrangements. Whether it is with a customer, he pays me a price, I provide him a product, I provide him a service. I think somewhere by elevating it to saying that it is fiduciary is way too much. I think truly that I need the data for a particular purpose, that reasonableness of that should be indeed tracked. Beyond what I need to retain it for, that it should be destroyed, should be assurances. That I will not trade in that data by itself should be a prohibition. But I think traveling to saying that you are trustee, I have wide and huge respect for Tata Group, and I think indeed you are trustees for the nation. But on the other hand, when you say that it is data, I think when it comes to commerce, to me, it has got to be understood that we are not here for just sweeping up data like a Google or a Facebook. We are here to deal with data because it adds value to what we do. When we collect KYC, as a bank, I'm required to retain it all through my relationship. And guess what? For 8 years beyond the relationship ending. Now, at some level, if I say I am a trustee for you, I have no clue as to where the judiciary will indeed lead the fiduciary definition into. So I would say we need to indeed combat this, thing of putting it into fiduciary. I take your point that the civil society looks at it in a particular way. And I guess that's going to be the challenge. We are all individuals. I am a customer as much as part of a corporate. Do I need to worry about how my data is processed versus as a corporate what I have gathered? For sure. But I think balances need to be struck. And to me, whether it is 18-month, 24-month or a greater period, I think the respect for data privacy has to creep in far faster. The penal consequences or what have you will have to follow suit in terms of what is the depth that the society appreciates it with. We are equally, even as we talk about data protection and whatnot, there is a parallel thing happening, let's say around Companies Act, legislated less than 5 years back, right? Where we are saying, please ensure compounding. Please take away penal thing because it is hitting the corporate sector. I'm saying the data protection has to yield ground to the same logic. If you are going to level that kind of penalties and so on, you're either going to scare us into not doing business at all, which I don't think this economy can survive, or for that matter, the onerousness is going to lead to honoring it in the breach rather than in compliance. To me, I think those would be the realities the committee and hopefully the parliament will wake up to. So that is what I just wanted to share.
Other thoughts on the floor? I can see Saugata, thank you. Anybody else, Yes, I have, we have, please, Raghuvi.
I'm Raghuvi, yeah. We haven't met.
Yeah, but I've seen your photograph several times in the last few days.
Right. So I'm Chief Risk Officer of IFL Investment Managers. Quick question. We actually, under RBI regulations, and in fact also market practice, we send data on customers who've gone past due to CIBIL, and now for large credits to the CRILC, the Central Repository of Large Credits. Now, CRILC I think is accessible to banks, but not yet to NBFCs. But at some point in time, I guess it will become like a corporate CIBIL, if you might call it. But CIBIL anyway is applicable. It's the same principle that is applicable. Now, CIBIL is accessible to other players also, and I don't know whether. So I'm not sure who all has access. Now, there we come to the slightly tricky question. Do I need to take permission from my customers upfront that I'll be uploading his data into CIBIL, which is as per the RBI mandate? And two, what if other people access it? I've kind of lost control on the data.
Credit rating has been specifically excluded. so specifically the aspect of credit rating has been excluded as an exception to the general rules with regard to data privacy.
Okay.
Is what my limited understanding of, I can claim no expertise on this subject.
No, you're right.
But I will let the other panelists add more insight. But my limited understanding is that if that information is being shared for the purposes of things similar to credit rating, then that you do not have to take consent and take all the other give all the rights to under the Data Protection Act.
Okay.
So,
Yeah.
so as Indranil pointed out, credit rating or debt recovery has been excluded. So there is no embargo in sharing the data with your, say, ARC or somebody. Similarly, the other aspect is it says that which is in pursuance of a legal requirement. So here, whatever RBI has issued would be a legal requirement on your business, and hence you would be permitted to do this.
Yeah.
One issue that I see is, while this law is in formulation and everybody is discussing its, what should be the right approach, a lot of regulators are taking this mandate ahead. And there's the RBI, which has already said that, I think 15th of October or something, data localization is the norm for all payments. And that's really kicking up a big storm, especially with companies like Visa and Master, and also with like Facebook, putting back their plans to start what Apple Pay and Facebook some payment, so that seems to be an issue as well.
And the challenge is that most of our e-commerce clients are in Bangalore, and we couldn't get them to Bombay because this is something that is worrying a lot of them. It's not just e-commerce, of course. It's a lot of people who have historically been using the likes of Azure and Amazon Web Services as their key service providers. So, for example, so when, not in the context of Lexplosion as such, but our first cloud-based solution, ComRisk, was from 2010-11 when there was no real clear sight of where we were going with data localization for sure. But somebody had, told us that, it's better to probably work with somebody who stores your data within India. So against, most sage advice, we went with a company which is called NetMagic, which has now been acquired by NTT, which assures you that the data will reside within India. I do not know what the realities of Azure or Amazon Web Services today are, but till at least a couple of years ago, none of them give you that assurance of 100% data, including the BCP. So most of them keep redundancies, backups, to make sure that even the last of the backups are stored within India, especially with regard to SPDI, where everything has to be the processing. It's not just about keeping a one copy, but everything. So I'm not sure if any of you know how, do you use Amazon as a web service provider or Azure as a web service provider? And is it something that you're worried about? And the question holds for anybody else.
No, you're right. So both these web services, hosting services, have various server farms across the world.
Right.
And as far as I know, there is no assurance that this is going to be stored in a particular server, in a particular jurisdiction. The SPDI rules did allow us to transfer the data abroad so long as, they provided a higher or an equal standard of protection, which again, considering our standard of protection was at a different pedestal at that time, pretty much included most of the world, other than some parts of the Middle East, I guess. But as things stand today, if the localization requirements are really enforced the way they have been put in the bill, the problem is not just of storing the data here. The problem is also the services we'll no longer have access to, because a lot of the service providers for a company like Unilever provide global services, and they are headquartered in a particular jurisdiction which would be outside India, and we will no longer have access to these services. So that's another concern that
Yeah. So a last comment from all the members of the panel, because otherwise my colleague who's a strict taskmaster will not allow us to break for tea and push us into the next session directly. So
Quick response on your comment on the point Naveen raised on data localization. So, I used to work with Intel Capital in the venture capital space. And about 3-4 years ago, the VC community felt data localization is going to be a great opportunity. Let's go and look at all data centers in India. So as part of the team, I remember we went to Amravati. Chandrababu Naidu actually has invited way more business in this space than any other state. There's Pi data centers. Then Karnataka attracted this company called NextGen. Kerala had one other company. We went all over India looking at the land, I'll give you examples, real examples of what happened. Data centers require a lot of real estate and a lot of dealings with the government, the sort of land you're talking about. You're talking about 200, 300 acres. That itself is a long drawn process. It's a 6 to 12 month to 18 month process. There are issues in India. Land records are not digitized. You don't know, it's not like blockchain. You know exactly how it's transferred hands. And it creates a lot of, for a lot of foreign companies, you're always worried, is this a potential FCPA issue? And many VCs went ahead, put in money in these companies. The ramp up time is about 2 years. Minimum 2 years. It requires a lot of manpower. It requires non-stop supply of electricity. So when they say data localization, maybe that's something to actually include in a representation to the government. India doesn't have that capacity yet. India does not have that infrastructure at all. So then you're back to Google, you're back to Amazon, Microsoft, Azure. And I think his point on integration is a key one. We're all global companies, and I can't say, India is different. I'm going to be unique and keep our stuff separate. So I think the default will really go back to a Microsoft Azure.
Right. Ayan. A last comment before we...
No, I think this legislation requires a further review. It needs to be made simpler in every sense of the word, whether it is infrastructure, whether it is the terminology used, whether it is consent and the quantum of the consent. I would still like to go with the previous 2011 rules that were there. They were simpler, and it gave, there's this basic thing. When we go too much into legislation and legislating every bit of what we want to control, then comes all these hair splitting, and that is where the problem starts. So long as you keep it broad and allow the business to operate on its own and operate within the four corners of the law, given provisions of the law, I think the life becomes simpler for the consumer as well as for the companies, whether it's MNCs or whether it's, outside companies. I still remember those days of NSDL, and it still happens. NSDL used to store their entire data in their own building. And then every day they used to take one cassette out somewhere in Pune to keep this thing. Every day that used to happen, I still remember. And somebody used to travel with that, small piece of this thing to have all the data stored somewhere else. So we need to make things a bit simpler, whether it is this particular legislation at least needs simpler, because we have to understand a lot of consumers who would not go through. If I have to, as a consumer, not as a corporate, if I was a consumer, if I have the right to be forgotten, look at the procedure given for the right to be forgotten, to apply to authority, and of course it gives a good, opportunity for the lawyers. That's, yes, of course.
Over to Shalti.
So I would say that it's, quite early days, and I'm sure the law will, when it is enacted, will be in quite a different form. So, and we are having this discussion at the right moment. So we as industry, need to pull in our thoughts and feed it to the government to ensure that what finally comes out is really business friendly.
Sure.
And also at the same time achieving its intended objective.
So I think we are cognizant of the fact that now this is a fundamental right, the right to privacy under the Constitution, and no doubt there will be, this is probably just one of many legislations that will come out. It's in the right direction. I think there is a need for legislation, but I totally echo the point of the panel that, it is complex and there needs to be a little more practicality brought into it as to how existing operations do not get totally disrupted, that it has a negative impact on the overall economy. So that's...
So with that, we'll conclude this panel. This discussion will probably have many more rounds of iteration. What we are planning to do is a more detailed session on data protection, where we'll also call in people from business as well as people from the information technology space to have a more comprehensive discussion on how to, action the data protection bill. We'll probably wait for a later version of the bill before we do that, but we'll do it sooner rather than later. We have a small break now, which is a quick tea coffee interaction break, and then we are supposed to reassemble at 5, but it's already 4:35, so we'll probably reassemble at 5 minutes past 5. But before we do that, we have a small we have a few mementos for the panelists, so we'll quickly pass them on, and then we'll all step out for our break, which is in the area just outside this room. Thank you. Yes, a round of applause, please, for the wonderful panel. So, Purnima, this is our effort to, bring some sparkle to your life. I hope you can. Thank you very much. Thank you, Shantanu. Thank you very much. So, since there will be others who will get it, if you, there's a little sketch that somebody that we know has tried to do of each of you, and put it in a frame and pass it on. If you don't like the sketch, absolutely feel free to let us know. I say this in all sincerity, because we just picked up whatever photograph we could of you from the social media. So if you do not like your sketch, do let us know. And no, we also asked each of you to get passed on you. So there was informed consent, and the data protection law thankfully doesn't apply anymore. So if any of you don't like it, I mean that's for the panelists. Please do let us know, and we'll get another sketch made. Thank you very much.
I'm sure all of us are on his friend list also. So.
Yeah, I'm not on Facebook, so maybe on LinkedIn though. Yes, LinkedIn, yes.
Thank you very much.
One, that's for Pramod. Can we also quickly have Pramod back on stage for a second, please? Pramod, are you still there? You haven't gone off for your break yet, so we'll. Pramod, thank you very much for your attention. If you like this also, same sketch.
Welcome back, ladies and gentlemen. And of course, we'll start our next panel discussions. And to moderate our next panel discussion, we have Mr. Murli Nilkantan, and he said that he'll do the introduction himself. So I'll definitely pass on the mic to him.
Good afternoon, everyone. Thank you for coming back to this session. We're going to look at risk in a slightly different way from the last session and slightly differently from Pramod's talk as well. I'll skip the introductions because there's these very nice wanted posters hanging out there with all our names and pictures on it. So I guess you know who we are. What I'm going to try and do is set out about 6 questions and then we'll take turns trying to address those. And like good lawyers, we'll start with definition. So we'll start with Raghuveer with how do you define risk? You have a different perspective on risk from the rest of us. So I guess we'll listen to the clients first and tell us what the risk is before we give you our advice and ideas on how we think we're going to manage it.
So actually we define risk as any difference in outcome from what was anticipated. And hence, actually even if something good happens that you weren't anticipating, we don't necessarily see it as an absence. In fact, we see that also as a kind of risk. Windfalls. Hence, for example, in markets, we take into account volatility, which could be positive or negative. So, and then it comes to finding out why is it different, what has changed, that kind of thing. This also means that I think every risk manager, or in fact every manager, everybody who's managing a business or part of it, also needs to be humble that as Donald Rumsfeld said, there are unknown unknowns. So sometimes you get bushwhacked with stuff which you weren't anticipating at all. You didn't even anticipate anything. It just happened. So that's when I guess partly a business continuity planning or where a nimbleness of the organization is important. Where things that you simply weren't planning for happen, then what do you do?
I come from a background of private practice and largely transactional work. So if you draw a parallel to transactional work, for us the contract embodies all the risk. So the simple method that classical contractual lawyers use is say, can we identify all the risks, however remote they may be? Can we identify, make a list? Then can we allocate, because that's the whole point of the contract, to each of the parties to the contract. And once you've allocated, you know what's in your little pot. Then we try and mitigate, and worst case scenario, insure, whether we self-insure or buy insurance on it. Can we apply something similar to regulatory risk, compliance risk?
Yes, to some extent. So as you rightly said, you can either accept a risk where you say you really can't do anything about it. For example, there is always a small probability of employee infidelity. But then you can probably, actually there you don't really accept it because you kind of transfer it away with a D&O or a employee infidelity policy. So in fact, now you can transfer that risk. So perhaps my example wasn't a great example in terms of, though it's a compliance risk, but, or rather it can be a compliance risk, but most importantly, it's a financial or fraud risk. But there are some risks which you have to accept. For example, market risks in our business, in the asset management or financial advice business. Then there are risks which you can transfer, which we just spoke about, which is either through a contractual obligation or an insurance or by buying an option, whatever it may be. In the case of compliance, you can have good legal counsel, whom you can say that I'll hold you to your advice. So be careful before you advise me. But then, of course, given that they are lawyers, so they will also have the right wording to probably avoid that kind of ramification. Or liability, or get liability insurance. Correct. Then you can treat the insurance, which is to mitigate it. Treat the risk, which is to mitigate it with proper controls, internal audit, having a good compliance department, hiring good people, that kind of thing. And lastly, you can completely avoid the risk also, where you say that it's too complex or it's something that I don't want to do at all. So, for example, when in the financial services business, there are clients, we formed an anti-money laundering committee, and there are clients who have rather dubious records, and we say that maybe we don't want to deal with them because there's too much reputational risk, we might get pulled into the dirt.
Naveen, one of your thoughts was on how do we evaluate this risk? Do we have methodologies? Is there a way of taking it beyond an accounting entry? What do you think? Can we think of how we can evaluate these risks?
I think there are different methodologies, and the problem comes up with statutory compliance because all of them seem to have the same level of risk. Sometimes I'm asked, how severe is the risk? Now, if there is a penal consequence attached to non-compliance, every other risk is just as severe as the other. Because to us, it means risk to reputation, and a risk to reputation coming out of 10 days imprisonment to 30 days imprisonment is the same. So where we flag non-compliances which involve penal consequences, the risk severity is always, at the highest level. So I think there are concerns around, a common industry standard on risk rating. I wish there was some single method to all of at least our statutory compliance, which, so we all knew that every company was being judged on the same basis as far as risk is concerned.
Siddharth, you had a thought on the reputational risk and how we can comply, why we should comply.
Yeah. So as Naveen pointed out, one of the key, kind of outcomes of, firstly, when you talk of risk in compliance, the biggest risk in compliance is non-compliance. So clearly, and that stems from your whole attitude towards compliance. So as organizations, when we are setting up, kind of robust compliance mechanisms, what we have to kind of base these, first is to create a culture of compliance. On this aspect of a culture of compliance, I draw an analogy to, from an Indian context, if you look at behaviors at traffic signals. Now, a lot of them treat traffic signals with contempt. You have people jumping red lights. There are others who will stop at a red light, but look for the policeman to see whether or not they can jump that light. Then there are others who will stop at the red light, but they will wait to see until a few others pass by that red light, and then they'll follow those, kind of traffic offenders. Now, that's the whole attitude towards compliance. So when you set a, culture of compliance, which are, kind of based on, kind of values and behaviors, that is how you, kind of, create a kind of a protective blanket for your brand and its reputation. And that protection to your brand and reputation is what makes you makes the organization a trusted company and a trusted business, which is where the value is created for that business.
I hear what I'll just come to you. I hear what both of you are saying, but in the Indian context, is there a value to compliance? Because there's really no downside to compliance. Show me an example where people have actually gone to jail for let's say, Payment of Wages Act, Employee Provident Fund Act, Minimum Wages Act. This is all human stuff, right? So when you're talking about company values, not paying the minimum wage is not a very high value to have. It's just basically human. But show me examples where anybody, any CEO, any managing director, any director has gone to jail for any of these things. Look at the Factories Act, where you have an accident in a factory. Look at the Boilers Act. So if you take legislation which are basic health and safety, human concepts, we've not sent anyone to jail. Very few, no, show me where has a big CEO been sent to jail or MD been sent to jail?
Definitely been prosecuted.
No, not
we don't want to see our director being prosecuted for.
No, I'm not saying not being prosecuted. I'm saying sent to jail.
Murli, let's understand with regard to that question.
Let me finish. Therefore, to a lot of businesses, they are looking at it and saying the risk is of non-compliance. Is it just that we'll have to pay some lawyer to go to court? Which might happen even if you do comply. With all of these legislations, you're likely to be prosecuted irrespective of whether you comply or not. It's the whims of the inspector. Therefore, the question is the risk really non-compliance? Is the risk going to jail? What is exactly the risk? When you said, and therefore, the response I'm seeking from you, when you said the risk of compliance is the non-compliance, is that really fair in the Indian context?
Well, I think your whole argument is premised on a assumption that the worst case outcome is jail. Now, when you're talking jail, you're talking of an individual. Here, I'm talking about compliance and the outcome or the impact it has on an organization. I mean, let's take the case of what happened to Maggie. Now, I mean, it was kind of if you look deeply into it, it was a compliance issue. And what it did to the brand and how much, kind of resources had to be put in terms of time, kind of man hours, management time and all of that to kind of bring that back on track was huge, enormous. And which is why one of the key things, message I want to leave is, it's not, the outcome is, I think compliance is good business. If you want to run a successful business, I think compliance is key.
That's true, and I take that argument forward. The first question which went across, what is the definition of the risk and how do we map the risk and why it is an important topic? Well, I understand the mapping of the risk needs to be in a three-pronged approach. First of all, we need to understand how much management time gets exhausted if at all an event has to occur. That's number one. Number two is the reputational damage which is going to make to an organization. And number three, when it comes to either a personal liberty or a penalty, which is an adverse impact on a human attributed, that's part of it, has to be put in a three-pronged map. And then we need to map the entire risk in a methodology. We say that, yes, if something has to happen, we will have to get into a situation where either of the three, and I mean either of the three, could get triggered. So when you are pointing out whether anybody has gone to the jail or not, I come from a multinational. We have directors who are foreign nationals. We have directors who are literally high in Indian fraternity, and any of the reputational mar to them could cause a real damage, and to their own credibility, to the credibility of the organization. And that's why the motto we follow, at least in Siemens, is zero tolerance towards non-compliance. So we take that at that level. And what we follow in terms of the risk methodology is basically the fear of unknown documented in a piece of paper is the risk for us. So it's not just the level of compliance in terms of the law. And we take it that the fear of unknown is also a risk for us. So that's where we play, that's our level playing field for us.
You wanted to add something?
Yeah, actually you reminded me of what Peter Drucker had said, that culture eats process for breakfast. So I think the tone at the top matters a lot. And that's true for government, that's true for any institution. And government and governance and and everywhere. So whatever be the type of institution, I think the tone at the top really matters. And somehow people do figure it out. Though the person may be mouthing the right things, that compliance is very important for us. We want to be a very compliant organization. But then at a transactional level, if you're not doing the right things, people get those little cues and they know exactly what is important to you. Also, the position of risk and compliance in terms of, it'll probably sound rude to say it, but it's the truth. How much you pay them, at what level they are. Do they have the organizational heft to be able to say no, speak truth to power? Because if you have a very junior, just graduated greenhorn fellow to head your compliance and risk, then he really won't have the heft. He'll keep getting overridden by more important people, by the big guns. Anyway, the people who get business probably command a higher level of authority, and perhaps should, because they are if they wouldn't get the revenues in, there would be nothing to manage compliance for. But at the same time, you need somebody who has that kind of authority to say no, or to say this is to hold the line, as it were.
Let me just take this a little forward. I don't know how many of you remember the Enron saga, but the most powerful team in Enron was Risk. And it had the brightest lawyers. I had the privilege of being there for a while. And they could say no to virtually anything. Didn't prevent Enron from going down. So how do we get that culture of the revenue, the rainmakers, the star salespeople meeting targets? And how do we reconcile that with being compliant? I mean, how many of you will have an experience where we're going to make $1 billion? We might have to pay a penalty of 10 million. How do you do a trade-off like that? Siddharth?
Well, I mean, so when you're looking at a successful business, it's not about, kind of making hay when the sun shines, and, it's not a, kind of, you're running an organization so whatever whatever actions you take in the interest of your business, it has to be sustainable. So from a long-term perspective, to draw another analogy, when let's take, we all use cars to, transport ourselves. So if you have to be telling your family and children about the value of wearing a seatbelt, so will you tell them that, wear a seatbelt because there's a cop at the corner of the street and he will, levy a fine of, say, 1,000 rupees? Or will you say wear a seatbelt and save your life? So I think that's the attitude which is required towards compliance. We have to create a sustainable organization who's, with a good reputation, and that is what will take the business forward, rather than, kind of make a killing on one deal and then be non-compliant, and pay that hefty fine. So if you're hedging on what the, kind of fine to the overall outcome of the transaction is, I think that's not the right thing to do.
No, we all know what the right thing is.
Yeah.
The question I'm asking is, can we actually veto any of these? Are we doing a cost-benefit analysis on compliance like we do on risk? So compliance is a risk. I'm willing to take the risk of 10 million because the outcome, which is fairly more likely than the risk, is that. I'll just come to you. I just want Naveen to answer, how do we say no to business?
No, I think businesses now are very aware. I want to make a differentiation here, and Murli, you actually hit the nail on its head. I think Indian companies and multinationals have different standards to compliance, and that is it comes out of the manner in which laws are enforced in our country, and that is a serious impediment to, I think Indian companies need to see the importance of compliance beyond the very issue that you just talked about. Can you do a risk-benefit analysis when it comes to compliance? I don't believe that is appropriate, because the consequences of non-compliance many times are, it cannot be pegged at just the penalty or the financial consequence that you can see in the immediate term. It has wide range. It can bring you down, and we've seen so many examples of that. Maybe not Indian companies, but we are seeing Indian companies too go that way. So I think there is now an opportunity for compliance professionals, general counsels, to be able to stand up and say, no, we can't go this way.
Is there a chance, and so that I'm drawing from what you said and what you wrote to me about, is to say that compliance becomes as much a value of the business, like you say, quality is a value. Yeah. In the same way as you say, we will have zero tolerance to everything. So it doesn't matter if it is a small matter, a big matter, if it's confidential information, if it's sexual harassment. So long as there are rules, we will comply. I mean, how many places do we see this kind of reflection? We see it with quality. In virtually every organization that I have known, they say quality is what we will always comply with. And in many ways, we have accepted that if the QA or the QC guys have an issue with it, then everybody listens. Are we seeing that trend with compliance, where compliance teams, leaders of compliance, are able to say, I'm sorry, this doesn't pass compliance, therefore we will not put it out in the market, in a similar way as quality? What do we need to do to make that a core value of our business, which is non-negotiable? And let me explain that a little further. When you look at quality teams in businesses where quality cannot be negotiated, pharma, for example, the mantra in the pharma business is everybody is responsible for quality, not the quality guys. Is there a chance that we can embed that value? Just like safety is everybody's responsibility. So if you go to good factories, it is not the safety officer's responsibility to keep the factory safe. Every worker needs to make the factory safe. Every manager, every foreman, every supervisor has a responsibility. And we made great progress with that. So when we give out safety awards, we give out safety awards for near misses. And near misses are not picked by the chap on the shop floor. They can be picked by housekeeping. They can be picked by anybody in the process. Anybody in the factory can get an award for a near miss. So if we can take, and is there a chance that we can change the tone of our conversations and say the value of the organization is already embedded in things like quality and safety? Can we add somewhere the same tone for compliance?
Is that you?
No, sorry,
Yeah, Murli, you are right. I mean, this is exactly how we have seen it in our organization. Especially the compliance topic starts at the very grassroots level. And when I mean compliance, it means EHS, it means quality, it also means the regular law compliance. So what we have done is basically we have a approach of bottom up and top down. So the top down comes, of course, from the Companies Act perspective, where now in the new act, it's all applicable laws has to be complied with, and there needs to be a robust mechanism. And the third leg of that is that it's functioning properly.
Yeah.
So all the three legs. So to have those three legs, what we have done is basically a bottom-up approach. So there is a cohesive arrangement which comes that there is a risk officer who actually takes inputs from each and every segmented business and then puts it together. And thereafter, it gets sorted out at the higher level, and each level of the organization actually puts their own piece of it. So virtually every risk at a certain level or a certain point of time has been seen by entire organization as a whole. And then that has been evaluated at the highest level of the organization. The ownership, then you actually draw the ownership of people. So if somebody sees that my risk is in the risk register, he says that, oh yeah, that means the company is taking it absolutely seriously. And whether I am wearing a safety boot or not, and whether I can hit myself in a site which is like 400 kilometers away from the headquarters, if that is also important to the organization, then the compliance is absolutely an important topic. And that's how we have grown the culture. And it doesn't happen in a day. It took at least 7 years for us to travel this journey. And over last 3 years, we have enhanced ourselves. And since, let's take that example of EHS reporting of incident is also a award ceremony for us. So not only near misses, reporting of incident. So we have taken that also into consideration in the risk methodology. So if you are putting a risk in the register, which can be a material one and which can actually come across to the highest level of the management, then you are actually awarded for that. So it's bottom up, and then we actually move it forward for a mitigation methodology. So that's how we engage the entire company.
Naveen, you said there's a difference between the MNC's approach to it and perhaps an Indian approach because the environment we're in. With a lot of Indian businesses now being impacted by global requirements for compliance, are we likely to see a change of culture? We've got, everybody talks about the FCPA. Frankly, I am a little skeptical of it. All it says is if you give a bribe, you need to have an invoice. So I'm not a big fan of the FCPA. And in fact, the analysis I did under the Prevention of Corruption Act goes much further. And it includes people like, for example, in the pharma business, doctors on the LIC board. So we have a much better system of legislation, at least, not necessarily enforcement. But, things like the GDPR, where now we're required to comply globally to a standard. In the pharma business, we have global pharmacovigilance, which means an incident that happens in India needs to be reported in the UK, has to be reported elsewhere. Is there now going to be a change where we say we can't have an Indian standard? Is it like export quality and local? We now need to have a global standard. And what will it take to get to that? Who will make it happen?
Yeah, it's a difficult one, Murli. I think Indian companies would sometimes even not do business because of concerns around it. It's so alarming to them that they need to go around all this detailed compliance and all these risks suddenly present themselves. But yes, I think definitely it's going to, Indian companies are changing and all these laws are having its impact. GDPR, definitely. We've seen, I think UK Bribery Act made some more difference than FCPA. And yes, the Prevention of Corruption Act now, and slowly I think enforcement in India will also improve, and that will bring about change. But how soon do I see it happening? It will take time, I think. Yeah, it's not going to be like overnight. We are going to be in the same. I have not had the opportunity of working with a multinational, but I have seen some of the standards, for example, that BP follows, and it's pretty onerous. As in, I've seen their anti-bribery and corruption policy and their practices, and you need to maintain a register of every government official who you've met and what your interactions involved, and whether you had a cup of tea or whether you had biscuits or whether you had more. So, that kind of rigor is not present in any of our compliance mechanisms.
But I'm thinking of a little more than just bribery and more than just corruption. It's compliant generally, let's say, with the disclosure standard. Compliance as required by contracts that you're likely to do, where they have imported several provisions of global requirements into your contract.
Most of our contracts now say that we will comply with FCPA. For us, another issue is like these sanctions, as in, suddenly Iran, where we were assured, I had, under the Obama regime, we had senior government officials from the US coming out to India and encouraging Indian businesses to open shop. They said, we would like Iran to join the global economy. Sadly, US nationals are not yet allowed to invest. So, but we want to encourage you guys to invest. We don't think that we are going to hold, blacklist you because you've invested. Please go ahead and a lot of companies did, including us, as in to some extent. Luckily, we didn't go out, unlike the European companies, go the whole hog. But suddenly, things have changed. and we are trying to tell all our 100 businesses all over, guys, if you have Iran on your, you're supplying or you're procuring or whatever you're doing, you need to disclose. We need to be aware. We need to understand what is the nature of that relationship. So compliance because of those kind of issues. So really, Indian companies are starting to take compliance very seriously.
That's interesting. We've dealt with the esoteric questions, conceptual questions of risk and compliance. Let's assume that we do have a culture of it. How do we actually go about doing it? It's very nice to say we'll do bottom up, top down. But do we have enough resources in this country, enough capability in this country to sit and identify them? It's all well and dandy to say we'll do it. But if you sat around to do a check and say, here is a business, can I check, to use a loose term, risk of that business? From a financial standpoint, you may be able to do it. I think we have some sense of how to measure it. From a legal standpoint, do we have the ability and the expertise to actually sit out and map each activity and map it to each legislation? Do we really have that capability in-house? I mean, yes, you can get the tools and you can get, Commerce to come and do some for you. But do we understand it internally? Do each of the business managers understand it? Their subordinates understand it, right down to the last guy. And what can we do about that? To me, Naveen, that's, the big challenge. It's well and dandy to say we will have zero tolerance. We'll say compliance is a value. We will say we won't give you a bonus if you don't get a sign off from a compliance team. Let's say we do all of that wonderful stuff. And then everybody's bought into the idea. But the chap at the bottom is helpless. How do we get them?
I liked what Raghuveer said about, it's important to find who is responsible for compliance. The position that the person who owns compliance holds in the company is a very important factor. Who he reports to. Indian companies, even if there is a compliance function, would report into the CFO. Many times now it is convenient because your Companies Act requires a company secretary to be designated as chief compliance officer. He is your key manager, KMP, and so that is our compliance guy. But unless you have a very senior person, I know that financial institutions do give more regard to that. You have a compliance or risk officer who reports into the managing director or the CEO. But I think that, to me, that is a very important aspect.
So that you've been on the other side of this. How does the compliance structure work there? How do we get people at the bottom of the chain who are really at the coal face of compliance? If they don't do it, you're sitting as a CEO, there's not much you can do. How do we incentivize them to do it? How do we help them do it?
Okay, so like in the case of safety, you can incentivize people, you can give a pat on the back recognition for things that they've done, like you pointed about, safety observations, pointing out near misses and all of that. So likewise, if you put, ethics and compliance on the same pedestal as safety, there is a way you could, kind of get it is, you have to go back to your code of conduct in the organization, and where, as we describe it as values and behaviors. So with some core values in your code of conduct, you can get that in, Raghuveer pointed out about, do people, down the line have the courage to report something happening in the organization which is non-compliant. I think as organizations, we should instill that, that those values and behaviors with speak up cultures and, have mechanisms where people can report non-compliances. That apart, you have it as part of your, kind of KRAs. So these conversations regarding compliance, it's not only about your sales guy going out and, kind of getting huge sales and making profits for the organization. It's not about it as much as we focus businesses and business leaders know what to do generally about how to deliver the business. But how to do it is very important in a compliant manner. And you can have this, your compliance record should be part of your performance conversation at the end of the year. You talk about incentive, as much as you can create deterrence for people going to jail. But, if it really hits the, kind of comes down to a performance conversation where you say, fine, you have delivered, XYZ on this side of things, but you failed on compliance, it's going to affect your performance rating. That is a serious conversation. It I think will have the desired impact, and it does. I mean, it's something that we follow.
Can you do the same thing in your business?
Yes. So I think Siddharth, you spoke about the KRA aspect. The other two ways that we do it, the way we control this or encourage compliance, is having a compliance manual, which kind of lists out all the laws which are applicable and the areas of the business which are affected, or the behaviors that need to be kind of a gist of what is applicable. It is a bit of a simplification because otherwise it will run into pages and pages. But at least it gives you an indication, okay, that my area is kind of touched by this. For example, customer service, is there some regulation that touches it? Account opening, of course, it's touched by PMLA regulations, by SEBI regulations, by RBI regulations in this regard. So that just the regulation, and so that they can refer back to it if necessary. It's also kind of protects the organization or senior managers, because people can't say, I didn't know this was applicable, because you're supposed to have read it and you know that there is something there. You better read it up because it's your area of work.
Is there a risk with the methodologies that we're talking about that we're reducing everything to tick the box, which was perhaps okay in a previous generation? So if you look at, go back to the old labor legislations, very easy tick the box, simple legislation. It gives you what the tasks are, what the timelines are, easy to do. With now regulations being less of tick the box, requiring some amount of application of mind, they're principle based. We're now asking for interpretation. We're asking for contextualization. What is now the new idea for moving away from tick the box, or to simplify things to tick the box? So on one hand, it's so complicated that somebody has to interpret the principle, or too simple that somebody has to contextualize it. So tick the box perhaps is a further simplification of that principle in an operational context. Who does that translation from principle to actionable items for compliance? And how does it actually address risk? Because there is a risk of this translation.
Absolutely. So clearly interpretation falls on the compliance department. It is, for example, a person like me who essentially is a risk manager, I push all these questions to compliance, and then they opine on what they think is the right thing to do in a situation of ambiguity. Now, there is an interesting question hiding there, which is, what do you do where the law is ambiguous, or where it's not very clear, where it's principle based? For example, assessment of suitability. That is a judgment question for a product. Now, you would say that usually a very aggressive product is not suitable for somebody who is slightly aged. Yes. But now put Mr. Narayan Murthy or Mr. Azim Premji there, and then it becomes a question of amount and not really, and perhaps not even amount given the net worths. You really can't have a standard set of rules. It's a judgment question, which is why we've kind of broken it up into a questionnaire to assess the person's risk, or assess the person's risk tolerance, or his risk appetite rather.
I think it's slightly easier to do with a financial product.
Right.
I want to hear from Siddharth and Naveen on how do you do it when it is not a financial product. There are no numbers to it. You cannot translate things. You can't give it weightage. With your business, perhaps with these products, you can do all of those things.
Yeah, we've given arbitrary weightages actually.
I want to know how arbitrary they are getting.
Right. But at least it gives you an indication. I mean, let's say we've said that if a person can lose money, large amounts of money, can he take leverage?
Yeah.
In derivative products.
Yeah.
So there we've given a large weightage, like let's say 8 or 10.
But you have net worth. So you work from one standpoint, which is person net worth.
Right.
I want to know, when it comes to the laws, what is that, North Star that you can look at and say, if this is the net worth, that is the risk appetite. But for legislation, which is now principle based, whether you look at SEBI, you look at insider trading, a lot of these things, there is no clear tick the box. How do you therefore put a value to it? So, these three gentlemen, I want to hear about how do you put value when there is no spreadsheet?
Right. Murli, there's one thing I'd like to add, which actually I've worked with different CEOs. And there was one CEO who took the call, and this is a call that perhaps only a CEO can take. He said, when there is an ambiguous legislation, I will always interpret it to my advantage. And I said, well, I wouldn't advise it, but if that's your call, ultimately you're CEO. Yeah. I mean, the buck stops there.
You go to jail, therefore you decide.
Okay. Yeah, kind of.
Naveen?
Responsibility, right?
Yeah. Naveen, how do you give marks? Pass, fail, 30, 40, 70%?
It's very difficult, Murli, as in, I think
so what's the process you use?
Yeah. There has to be some discretion, and who is going to apply that? I think at the end of the day, business takes the risks. We can guide decision making. We can say what the implications could be, but once they have, like the CEO has to decide. As in, if he thinks that this is within his comfort zone and he has control over elements, so as to not let that risk crystallize, then that's his call, I think.
So the reason I'm asking this question is, if you look at the recent trend in the US, risk and compliance has gone to the General Counsel's office. And effectively it becomes a black box exercise. So it goes to the General Counsel's office and comes back with a no. And frankly, a lot of the businesses don't know why it's a no. All they know is it's gone to a black box and the answer from the black box is a no. And amongst the peers of the General Counsel, they may have a discussion about it. But the people who actually run the business are basically told no. In the old days, it used to happen to insider trading. If you remember, including fund managers, you'd have to get permission to trade on your own account. And basically, you'd get a yes or no answer. That's all you would get. Nobody would explain to you why. Are we getting to that stage in India? Is that a desirable place to go to? Where you can't sit and write memos, which actually come back to hurt you because we don't have privilege in India. So is it a way to go about and say, this deal needs to be cleared by the General Counsel's office. He's the repository of compliance and risk. And the General Counsel may have his own notes, but otherwise you trust the man or the woman there to say yes or no. And then you basically, in the interest of the organization, accept that yes or no answer. Is that a way forward?
I think with General Counsels becoming more empowered, it becomes more of a collaborative exercise. The idea is that you share in the risk. I don't think you can allocate responsibility on any single person. If it is a subjective determination of what meets compliance, yes, and there is two views which can be taken, yes, it has to be a decision that is taken by the head of business and the head of compliance, or General Counsel, if that be him, together, because they know that this decision has implications for the business, for personal liberty in certain cases, and then stick with it. So I think that decision making is it will be shared between the person who is best placed to understand what the risk is and to the business head who's going to bear the consequences really of that decision.
Is that been your experience, Siddharth?
Yeah, so, the compliance culture can also swing the other way, where people will come to you. So I often tell people on the leadership team, who sit alongside me said, "Stop treating me like your family doctor." So people always, for everything. They just keep coming, and then most often you're giving wise counsel rather than legal counsel. So that has the kind of the other impact. And like Naveen said, I think increasingly, I think general counsels are using a collaborative approach. We don't sit back and say that no, you can't do it. Find ways of clearly explain to them what the issue is. So which is where I talk of culture of compliance. They clearly understand why this can't be done. And the other point that you made about how do you identify the risk? Well, a few years ago we did a gap assessment. I mean, around the time when these with the advent of the New Companies Act, where some of the compliances became more stringent, was when when from a board perspective, at every board meeting, I'm the guy who's there, telling the board that we are running our business in a compliant fashion, and the board takes my word for it. But the point is, few years ago, I mean, on the basis of what other people were saying, I would certify that. But the point is, which is why we had to look to, kind of a mechanism like what Lexplosion offers and other people in the business do, the compliance firms. But when we did that gap assessment, when we decided to get this automated system to manage the compliances, we found that we were almost there. I mean, in terms of compliances. So there were people kind of in faraway locations doing the stuff they were supposed to do, probably not knowing that what the consequences of the actions. What I mean to say is that they probably didn't know that this was what the activity that they were doing, or was related to some compliance. They just kind of came and said, "This is my job." They would do it. It's now they're now being made aware that this sits in kind of your activity. This relates to a compliance. So now they are being explained the activity that's being carried out and the consequences of that not happening. So, which is where I think the risk management is coming into play.
I think it's an excellent example, idea, and in the example that comes to mind for me a lot of times is the pharma business. Non-compliance means your factory shut down. It's not as if you can do anything about it. It's pretty much a straightforward thing. So suddenly it heightens real money cost. You shut down the factory, basically you're losing money hand over fist, you're losing market share, everything's gone. But most businesses don't have this kind of sensitivity to non-compliance. So what can we do when the business is not so sensitive to non-compliance, especially in the Indian context where, as you said, everybody is passing the red light. So if 4 people have passed, then being fifth is fairly safe. So what can we do? We can't change the culture overnight. We can perhaps change the incentive model to say, even if you're a sales guy who's made twice what you are expected to make, if you don't meet the compliance green light, then you don't make a bonus. But what else can we do when companies are not so sensitive to compliance? We are forced as general counsel to try and rate critical compliance, important compliance, nice to do compliance, can be ignored compliance. How do we have these conversations where, we say it's non-negotiable and then you come across as being difficult? How do we have these discussions? Give us some tips. Give us some nice punchlines to give back.
Again, sorry.
We'll start from there.
Yeah, okay. Thank you. So actually, it is kind of in continuation also of the last question which you had asked, how do you ensure a culture of compliance? So we spoke about KRIs. We spoke about having a compliance manual. Probably the third is to have an expressed whistleblower policy. So, to anybody who says it doesn't work, it worked with me. Where the head of compliance, the CEO, and the head of risk were the 3 alternative contacts given. We even gave alternative contacts because if one person is not there, or if the person is somehow feeling not comfortable with one person, he can get to an alternative person. So I think two areas where this is most sensitive is, one is of course if there is a compliance problem. So they got back, somebody got back in secrecy. He actually went through the trouble of creating a fictitious email ID, and then
We've seen that.
Oh, you've seen that, okay.
Anonymous email ID which can't be
Right.
Yahoo account,
Yeah.
account, Dropbox.
So Mickey Mouse had something, and Mickey Mouse also sent me, and I wrote back saying that, dear employee, thank you very much. We'll investigate this. We investigated it with a screen crawler, and we found malpractice. So. And the other area where this really happens, I think a whistleblower is very important, and there it's a prevention of sexual harassment committee, where also people want to report things in confidence, and then you have to kind of investigate it.
Give us some punchlines. Come on. What do we tell businesses?
Well, let me first bifurcate.
I want thesaurus for no.
Absolute. So let me bifurcate this question. First of all, let's bifurcate the compliances into different levels. That's the question, how it works, right? Because then you start at least the discussion, and you open the door for discussion. If you say absolute no, then it's a block. So you are basically pushing your own team members apart. So mapping of compliance is absolutely important. And when you start the mapping, first of all, the way we did it is basically from our experience, we did it in 3 levels. One is proactive, ongoing, and contingent, which is a standard format of any compliance. So that's the legal format of compliance. Second, what we did is we said, why shouldn't we start with a group which is very, very important for the organization and which has got the maximum one and which is concentrated. Let's start with company secretariat, for example. So company law. Immediately we said, okay, fine, because finance is also very important. So let's start with finance and treasury. Then the next one is EHS, because EHS is already there. Then real estate. And then you move on to operational law. And when you go to the operational law, then you find that there are varieties there. When you have that varieties, you have to then start segregating what is for establishments and what is then for on-sites. And then coming a little bit more is in terms of what is the level that we go into operational compliances. For example, I don't know how many people knows that storing of diesel for more than 10 liters is also a compliance topic. Yeah, so it's a requirement. And you will see most of the registered housing societies do store it. Yeah. And I don't know whether they are doing that compliance or not. So when you start telling them the real life examples, when you start discussing with the factory manager that do you really know that the welding goggles is a requirement, it's not just for a requirement because your person's eye can be damaged. And then that is the way you actually move each single line item of the compliances. And then you move it together, and it's a journey. It cannot be today yes and tomorrow no, or tomorrow no and today yes, sort of. It is not a binary thing. We have to take that journey and process together. And that's where you have to get the buy-in of the people who actually do that compliance. And that's the root level where you need to target. It's not the target is not the CEO sitting at the boardroom.
Yeah. Okay.
So we face this many times, as in like companies are like, do we need to really advertise in the employment stock exchange? Employment exchange. Yes. Like only the Mahindra legal department requires us to comply with this stupid law. So so we are like. For me, my only crutch is Siemens is doing it, BP is doing it. We want to be a global company. We want to compete with the Toyotas and we want to compete with the GMs. Then we want to show compliance like they do it, and which means maybe advertising the job at employment exchange if you have to.
Siddharth?
So all of what Sagato and Naveen said, kind of completely resonates with me. I think one thought that I have in terms of how could we, kind of drive and drill it down in the organization. I think you should start with the leadership team. I think you clearly have to get commitment from the people who sit with you on the leadership team that this is the way to go. And if you get that commitment from the top, and then it becomes a lot more easier. So, kind of in the oil and gas industry, all of our meetings, almost every meeting would start with a safety moment. We have, in the last couple of years, we have now made it a safety and compliance moment. So anybody who, picks on, kind of a near miss or something that, kind of was thing, brings it up in a team meeting, and, so it's almost like a lessons learned. So once that happens, I think people become more and more aware of the consequences, and it kind of becomes a part of your DNA. So if you bring it to that, and then after some time, people take pride in, kind of having, being part of this whole movement. So we have, got to a particular level on safety. We are there on compliance as well. So not to say that, kind of there will not be misses, but we are on the lookout for those near misses that happen. So.
Well, time's up. It's 6 o'clock. Thank you so much, gents. It's been great fun. I hope you guys enjoyed it as well, but I enjoyed this discussion. And here's to more good compliance.
Thank you, Murli.
Thank you.
Thank you so much, everyone, for this intriguing session. I'll quickly call Indranil to present the mementos.
Thank you very much, sir. If it doesn't look like you, let us know. Better than me. Thank you very much. Thanks so much. Thank you, sir. Thank you. Thank you. Thank you very much. Thank you. Thank you. Thank you very much. We did it on time.
You actually didn't invite any questions or any comments.
I had many questions.
So did
I.
But it was 6 o'clock.
Murli saved us. But the policeman said that you have to get out.
6 o'clock.
So we follow the policeman's instructions because
We'll all be around. You can welcome to ask us. You'll be around, so you can.
So at least I had several questions, but we'll wait for the break after this.
Sure. So we'll quickly move to our last session for the day. And the topic under discussion is legal technology and its adaptation by in-house teams. Our panelists will explore how the latest software tools in legal risk management are changing the method and the efficiency of in-house departments, and perhaps even making redundant the lower levels of chain. And to speculate where this trend may be headed. So I'll also request Indranil Chaudhary to quickly come up on the stage, and he'll be moderating this session.
Before that, we'll remove the previous speakers quickly from our lives. And we stand between you and wine and cheese, so we'll be cautious and conscious of time. Can I please request Ganesh Parameshwaran, who's the General Counsel for BIC India, to join us? Can we have Preeti Balwani, General Counsel for Kraft Heinz? Samir, the Head of Legal for Shriram City? And of course, Shubhangi. Yeah. Shubhangi, who is the Head of Legal for ASI Pharma. Thank you all for the microphones hopefully are still working. And I would request again for this panel to be as interactive as possible, because Pramod, of course, guided us brilliantly through the keynote session on the aspects of legal technology that we as organizations focusing on it should now start attracting or focusing more attention on. We, of course, as an organization, like I mentioned at the beginning, didn't quite know that we will, focus on legal technology when we started. We were more compliance consultants who slowly got drawn into legal technology. And now that we are there, we see that there are tremendous opportunities to do different things out there. But one of the things that we realize is that it's easy for us to keep thinking of newer solutions, but we also recognize that in-house legal teams have their own challenges of working with business, working with finance to implement technology solutions within the organization. So I'll start with the ladies. So I'll start with you, Preeti. What has your experience been when you've tried to implement legal technology solutions? What's worked and what's not? What are the things that have worked for you and what has not?
Good evening, everybody, and thank you, Indranil, for having me here. So some of the things that I can tell you from our experience can be drawn from the previous session. A lot of it is predicated on risk and compliance, and how do we achieve zero tolerance to risk and ensure that we're 100% compliant. When it comes to technology, and again, this is experimental for us because we are actually trying to move towards technology for compliance solutions. The first thing that didn't work for us was ignorance. We just didn't know what to do. So we had a problem and we did not know how to solve it. So it was very much exploratory, trying to figure out who does what is the solution? Do we understand the solution? Does the solution give us the end user computing ease that we need? Does it really solve the problem? So a lot of it was spending time to educate ourselves to see really what is it that we want, what is it that we need, what are the gaps, and how to fill that gap. What works is that there is a labyrinth of regulations, especially if you are a manufacturing entity and there are so many multiple voluminous compliance requirements. What technology does is it helps me prioritize. It reminds me what needs to be done when, and it removes some of the time that is spent by the compliance officer or by the legal team trying to keep track of things and ensure that I don't miss something. So that really I feel is my number one sort of pro when it comes to moving to technology.
Thank you. And Shubhangi, my question to you will be that you actually, was a decision maker, for example, at SI Pharma when it came to identifying a compliance solution. What we realize is that in many cases, the decision to actually implement a solution is because of some mandate from the board or, mandate from the CXO level. But it's a fairly longish journey from there to the actual implementation. What was your experience and what are the main issues that you faced when you actually tried to implement a solution with regard to compliance specifically in your organization?
Yeah, right, Indranil, you're right that it's actually a mandate, company law mandate. But in my present company, it was me who was decision maker, and it was me who wanted to implement a system for that. The challenge basically was resistance. Okay, and it was, why, we are already in compliance. And yes, indeed, the company is in compliance with all the laws, and we are actually a zero litigation company. So, except for some tax assessment complaints that are there, there are no show cause notices, etc. So they said we are already in compliance. So why do we need to? So it started from explaining them why the need. Okay, because they already had a system like one pager. In one page I will say certify everything that I am compliant in drugs and cosmetics law, I will comply with Drug and Magic Remedies Act, and so and so. I said, oh, okay, then do you know what exactly the law says about? Because today in general you are certifying that you are in compliant drugs and cosmetics law. But is the entire drugs and cosmetics law applicable to you? or only a part of it. So it started from explaining them why, how, and how it will be beneficial to you. So you are only certifying at present what you are actually looking for, looking into the helping into your systems that way. So then those things actually help them to understand vis-a-vis that today if I give certify that I'm in compliance with drugs and cosmetics law versus I'm in compliance with the section so and so of the drugs cosmetics law. So that's where I had to actually explain, and fortunately it worked.
So change management, I think, is at the core of what you said, and our experience as third parties who are trying to implement solutions is that organizations which have really focused on change management in a structured manner for the first 6 months of an implementation of a new solution have been a lot more successful with a solution than people who have just gone with a top-down approach and just insisted on people down the line being forced to do compliance, which in most cases hasn't worked. But coming back to for example, in your kind of a setup, Samir, what are the key legal issues that you believe technology would be able to solve?
See, Indralin, the answering a question from both from the insurance perspective and also from the banking perspective. Okay, it's a very wide compliance framework, because there is a huge amount of compliances that you need to meet, and also there are varied laws. It actually gets quite perplexing for people at the business. Okay, in insurance, there are a lot of things that you need to ask for. You need to manage a lot of things. You have to do things in a specific format, and so this brings a lot of a need for education, and that's what even IRDA, if I have to talk from the insurance perspective, insists that anybody who's doing sales has to be going through some bit of some hours of training, and then he has to pass some exams. In banking also, if you look at it, there is a huge number of laws per se in terms of whether it's a banking, whether it is FERA, all the economic legislations that there are. This gives, and there are a huge amount of questions. Okay, you keep, the business guys keep coming to you. Oh, can we do this? Is this, because everybody is trying to stretch the last mile that there is. Everybody says, and that as usual, the often remarked to you is, oh, this is my competitor is doing this. Why can't we do it? So this is something which is quite distinct. So you need something in terms of giving him instant kind of solutions and also making him aware that this is what it is. See, it cut both ways. There are times where even the compliance guys are not very happy to come out and give everything transparently. Okay, let me also put this, because I've seen something. There are times where they want to keep an ace up their sleeve and they want to really do things differently, because they can then interpret the way they want to, looking at the situation. So, but when you put it in a systemic thing, you have to come out and say what it actually is. And of course, it's a changing field. Today a citation comes and the interpretation changes. That happens, but that is not something which we are, we can change at that given point in time and tell why we are changing it. But it cannot be an ace up the sleeve situation. So it actually requires a lot more effort from both the compliance side and also the buy-in from the management to go in for a technology kind of a stuff. And I always had a pushback on that.
So just to add to what Samir is saying and to your question, the easiest sell for technology is litigation management. There's dollar value attached to managing litigation, so it's the easiest sell. Then the other sell, which is understood, is the compliance enabled technology. Again, there's risk associated to it. The tougher sells are contract management, which is something that you have to sort of convince them to say that if I spend so much money on a technology driven solution, I will save cost in and do the cost benefit analysis of people cost, time cost, business turnaround time, etc. For my business, the other thing that is a technology plus, or is a now we are moving towards, is labeling requirements, advertisement,
legal metrology,
advertisement requirements, product claims, product labeling, all of that, when it moves to a technology and there are checks and balances, and it doesn't get escalated beyond, or there are checks in place to ensure that it doesn't move to the next flow of the process, which mitigates risk, and labeling risks or advertising risks are very critical to FMCG, very critical to the food business, and it can result in a lot of loss of revenue. Everything that is predicated on the quick business turnaround, quick cost benefit analysis is an easier sell for technology.
So Ganesh, I'll bring you in here because you have, you had HUL, Marico, and now Big, all, heavy lifters in the area of legal technology, some of the early movers in the area of legal technology. What has your experience been when you've tried to, influence the decision of a business team in terms of what makes it tick for them?
Sure, I think I'll sort of shift the needle the other way. There's been a lot of sort of corporate leader bashing and us being victims. But if you're honest with ourselves, I think the challenge is for lawyers to be comfortable with numbers. We are good with abstract stuff, but we are not really the best with numbers. And we are not ones who are usually forthcoming with KPIs for our departments. I think if you really even look at the large legal functions in India today, or perhaps even global legal functions of some companies, I think there are like 1% of the legal departments would have KPIs, very objective KPIs for that department. And sort of when you go through the annual appraisal process, it's a bit fuzzy. Na ye project ho gaya, wo project ho gaya. So it's not like how you're doing appraisal process for a sales guy. So the challenge, of course, is to metricize your own department's work, get granular. And then once you metricize it, you're able to objectively demonstrate the cost saving or the cost benefit of a technology intervention onto it. So if you look at it from a contracting perspective, and if you're like a legal department of a listed company, how many contracts are there where we have given away unlimited indemnity? Now that be something that would worry the audit department or the general counsel of a company, saying, oh, I'm carrying, or maybe it's like a default in every contract. You just don't care about unlimited indemnity clauses and you're just giving it away. And there could be other contractual cases, covenants like that you put in. So yeah, I think the buzzword here is really metricizing it as lawyers, making a business case, writing like a capital expenditure proposal for your tool and justifying a ROI and when will the tool pay itself out. So yeah.
Okay, so you bring in a very interesting point, and if with the permission of the panel, I'd like to open it up because lots of senior lawyers out there. Do you? I mean, and this question is for everybody, but Honesh, you've been here from the beginning and you haven't said a word till now, so I really had to bring you in if possible. Is it really practical for you as the head of legal for a large group to set out KPIs for every lawyer in your team? And if somebody can give the microphone.
I think this is the discussion we keep having with the HR, because defining a KPI or the KRAs, what they talk about, they use the same standard what they use for sales. So that's the first challenge what we face. I think what we do is we try to make it as generic for a legal, and we do make it some kind of a direction for the department to work. Because as a function, we know what we expect from the team, but unfortunately, we still need to kind of crunch that to the format of the organization. So we do have a very a KPI which can be defined for us, and it's definitely different from the sales, because where the 3 or 4 buckets which we see, it's difficult to fit some. I think at some time we force fit some of the KPIs because the organizational format requires. At the end of it, the way we look at it is, at the end, during the journey or the end of it, did we give them a clear direction what they need to walk through and how they have to achieve, and at the end of the year, have they achieved that? I think That's the parameter we look at when we're defining the KPI. But it's definitely different from the sales. It's very more objective in their assessment.
Anybody else? Because I think why I'm bringing everybody else into the discussion is this is a very critical part of our journey when we are trying to establish why or establish need as a technology, legal technology provider. We inevitably come up with this question of there is no way of measuring what value you bring to the table. And a lot of times that's probably because of the reason that Ganesh is citing, which is there isn't a clearly identified set of values that the legal team brings. They're risk mitigators, but how do you quantify that? So, Pramod, I see that.
Yeah, I think there are some areas which are indeed matricizable to the point which was made, and some which I think are indeed more indeed abstract, if you will. I think there are 2 or 3 ways that one can talk about it. I think if one has to go to litigation, there is a clear value of a claim. Whether you can provide for it, you should provide for it or not. The outcome, maybe not with a certainty today, but that over a period of time you will have the outcome known. So I think that is indeed capable of being matricized and monitored at some level. But I'll just take it at a different level. And I think I both read about it in the Black Swan and something which will make sense for at least the lawyers in the room in that sense. What is the value you would have put to the aircraft door to prevent a 9/11, right? And to me, I think it can't be valued. If you had indeed stronger doors which didn't allow the hijackers to enter the pilot's area, the cockpit, then to me, 9/11 wouldn't have happened, right? And I think that's the constant example that legal needs to play to its counterparts in the business or the management or the board to say, there, but for the grace of God, go I. We have to constantly reiterate the examples that are happening around us to say, but for us taking this call is why that's not being visited upon us. And somewhere I think we need to both be alert, watchful of what's going on in our industry, what's going on around the world. And that I think is, as I said, you can't ascribe a value to that. But clearly people get it because they are reading the same papers you and I are, they are following the same trends we are. And at some level, being able to correlate and draw that to them, I think matters quite a lot. The other, and just to, sort of close the loop, is, again, it's about the positioning of legal. To me, it is both a control function and a support function. The control aspect is what I think at times doesn't register, whether with the HR counterparts or whether, with the businesses at times. But it's the ability to say no, and the ability backed up by not the black box, but really a reasoned thing to explain why the consequences are not something which the organization can bear. I think those really are how I would sort of put it.
I think just to and this was a point that I had with the previous panel as well. I think some of the interesting idea. Is this predicated on a culture of where you see the GC? Is it dependent on a company's organizational structure? And does that need to change in order for us to look at compliance and risk mitigation? That is really the question that we need to ask. And is it predicated on some of those premises that if you are in the C-suite, if you are as part of the executive leadership team and you work cross-functionally, is your function, does it have a seat at the table, and are you truly an equal? And whether so Saugata said that there is a culture of top down and bottom up in terms of compliance. But there should also be a culture of cross-functional equality, and some of the things that we do at Kraft Heinz is the fact that every single function participates in every single business strategic discussion. So, for instance, there is an executive leadership team that reports to the managing director that participates in every single strategic management decision that is taken, whether it is going to a new economy, giving a consumer offer, looking at the HR, organizational people representation scores, performance reviews, and therefore nothing is silos. There is cross-functional sensibilities that come into every decision making. And the other point that Pramod said, where I find that Kraft Heinz is unique, is we have something known as management by objectives, which is a technological solution that helps us monitor and map KPIs. And it's one of the first companies where I've actually seen every single KPI of a legal team being measured by some metrics. And some of those metrics are so sophisticated and well thought through, in the sense that there is a guidance, there is a definition, there is a global repository where we will have an analysis and understanding of what the KPI is, what are the metrics of the KPI, what's the definition of the KPI, what is it that you need to do in order to achieve the KPI. So for instance, for legal victories, it's a defined list, but you don't need to meet 100% legal victories. 90% achieves you the score. For instance, something like a food recall is also a legal KPI. It's a cross KPI across quality and legal, but it is equally divided between two functions. And it simply means that if I miss my KPI, and one of which is zero-based budgeting, so if I shoot my budget, I lose that KPI, I don't get my bonus. And it's as simple as that.
That's very interesting.
So that's the manner in which we incentivize, we measure, and we ensure that compliance is not just bottom up, top down, but it is completely cross-functional.
And that's probably the only way to handle compliance, particularly, of course, this discussion is broader than just compliance. And so in terms of just taking the discussion a little forward, and we, I see Soham has come back and taken his seat, which worries me immensely. But the question that I would like to ask all of you on the panel is, as users of legal technology and of legal solutions of different types, what do you want an organization like us to focus on? I think the basic solutions are there in the market. There is a compliance solution, there is a contract solution, there's a litigation solution, and there are plenty. At different price points, different, features. But what can we do, keeping 2020 and of course beyond in mind, in terms of assisting you? What are the real challenges that you are facing which have not been taken care of or not even been thought about by people like us, that we should we're looking at now? I'll start with Shubhangi and then take the discussion forward again.
Thank you, Indranil. Now, see, like in highly regulated industry, like a pharmaceutical, now we're already in compliance. We talk about local law, but when we actually had a discussion with this, my quality and regulatory were also concerned. Oh, okay, I'm concerned, compliance with the drugs and cosmetics. But my more worry and concern with respect to the international laws that we have to be compliant with. Now, the manufacturing side is US FDA approved, MHRA UK approved. Most stringent is Japanese law, DMA. So, is there anything, something like where I can actually monitor my compliance with respect to that also? And we did actually initially, when we were thinking of implementing this system, we thought of those things also, and I thought there was some limitation with respect to that. So I would appreciate, later on, which we could merge that too also. Then one more challenge, when we had a challenge, like we had also some tools already, like labor contract, separate tools. There was already labor contract related tools, separate tools in the system. There was HR things, and this was also one more challenge. Okay, I have a labor law compliance tool. Can we just is that sufficient? Can we just merge, or can we just exclude this part? So integrating those systems also into this is something that I would look for.
Ganesh, so integration is something that we, of course, are faced with, or something that we are asked for, from time to time. And one of the key aspects that we have, one of the key challenges that we as an organization have faced when we've tried to actually take the integration discussion forward is mostly the integration is with ERP systems. And mostly the organizations that we work with, the ERP systems are global ERP systems being run by the likes of SAP and Oracle. Now, for any two systems to really talk, there has to be what is called a sharing of APIs. Now, a lot of cases, what we've recognized is that these larger global organizations have several restrictions on sharing of APIs with third parties. The other challenge that we have actually faced is that the way we, for example, deal with compliance now is we inform about the payment of, say, gratuity or the payment of provident fund. When you integrate with an ERP, you are not really looking at a solution where you still have these, messages going out, these information nuggets being sent. You are actually looking at a control point within the ERP where if a person has completed 4 years, 7 months, 16 days, or whatever that number is, there is a trigger that goes somewhere that there has to be a provision of a certain amount of money because now gratuity becomes payable. So our responsibility becomes very different when an integration exercise happens. Why I'm saying this here is a lot of times this request comes in without this thought having been fully thought through, and therefore the integration discussion kind of falls to the fails pretty early on in the conversation, and we never really take it to the next level. Sorry, Ganesh, I wanted to actually ask you this question in terms of what can we do now for you beyond whatever support we've already provided. What are the, is there any analysis, is there any thought beyond what we've done? And I hear Shubhangi on the international law aspect, which of course we are now trying to work with some of the, third-party global organizations which are looking at international compliances a little more seriously than they did before. But from a technology perspective, how can we help you better?
Well, I think the generic answer to that is, I think for the GC to really make an assessment of how the function can move on to better value-adding jobs, not just turning out standard contracts the whole day, procurement contracts or advertising contracts, changing one clause or half a clause. It doesn't add value. One of the CEOs that I worked with said, what is the stacks of paper on my desk that I have to sign as contracts? Can you automate the whole thing? I mean, we are in a digital society. Why the hell can't this all be digitally signed and be archived? So, I mean, CEOs are also...
But do you still insist on them initialing every page? Ideally, if there are financial implications, signing on the side as well, and then signing on the main page, or have you as in-house legal counsel leaders now advised your your CXOs that they can just sign on the signature line and get on with it?
Yeah. I think it depends on whether they are standard form contracts or there are specific variations in the contract that you would like to draw their attention to and get them to initial. I think the standard policy is you sign on the last page and get on with it. But even then, if you're a large FMCG company, let's say like Hindustan Unilever, which some 800 distributors across the country, imagine each regional manager getting 200 contracts on his desk every year saying, these are my distributor renewal contracts. Even if it's an addendum, it's a whole lot of paper to sign and archive and manage and keep turning them around every year. So I think the
problem, and maybe we don't need to overemphasize it because everybody knows how difficult it is. But we need to ask some of the really difficult questions, because what we love to do is we like to grab things from other legislation, stitch it together in sometimes a
I would like to believe I'm not taking sides here, and of course my inherent question on data protection had a fundamental flaw, which is that the data protection bill only applies to natural persons, and therefore corporate data to a large extent might not be covered. So before anybody else catches that flaw, I should clarify that myself, because I hold myself out as an expert on data protection. But having said that, this is a question that we inevitably face when we're looking at data with regard to clients, and question that we a lot of times seek approval for us to be able to access their data, and we're immediately told, like you're saying, that globally it's not allowed. Purnima, you wanted to make a point, so.
Yeah, actually it's more of a question to you. Yeah, I just want to flip the question. We've been grappling with this at Tata Sons and many of our other companies. A service provider would have access to compliance data from many Indian companies, and it would be a nightmare if there was a data breach. And a lot of data, I mean, Tata Sons could say because of TCS or even its arrangement with Microsoft, it's on our servers, but not many of our other companies have that option. How secure actually is data on on the servers that you all use? All the compliance data is mapped. All the litigation data is mapped.
It is reasonably secure, is pretty much all that we can say. The data resides typically, especially with providers like us, for most of our clients on the cloud. Now that cloud security is something which is, so we'd like to believe that these cloud service providers, and have there been no breaches, of course there have been, provide this as their core job. So they're probably a lot more conscious of the security risks that they carry. So of course they have all the certificates that are required, etc. But beyond that, what we have experienced is that if you buy the right level of security, you do get a fair bang for the buck. Now, the only way to test this is by seeing whether there has been a genuine breach. Now, we have been using, for example, our cloud service provider for the last almost 7 years without any breach of data. Now, that's the only way we can say that it seems reasonably secure. But what we also encourage all our customers, and many of our clients are in industries like pharma, for example, which are fairly well regulated, is for them to do their own set of testing, which gives them that assurance. And in some cases, what we also recommend, if you believe that the risk factor is fairly high, is tell them that they can keep the data on their own server. So the data which is actually, so there is one aspect of compliance which is information that we are passing on to you, which is really not, confidential for you. What is confidential is the data that you are uploading into the system. What you can do is keep that data in your server if you feel that's more secure, and just have a link out in the system which then directs you back to the server. Coming back to your question of security, I'm not a technology person. Most of us here are not. Soham, who somewhere in the room is.
Actually, as a risk manager, obviously information security risk is something that I have dealt with. One thing that in my last job, we had a CISO in the organization, and what he recommended was for contracts going forward, we add clauses in for vendors that we will be able to review their information security arrangements and do a VAPT, a vulnerability assessment on their systems or databases. Now, the issue with that is not everybody agrees to that. It will depend on the size of your vendor, or, for example, where he knows he's a slightly monopolistic situation, he may say no.
And also the practical realities of VAPT is that if you have to do a proper VAPT, it has to be done on a live environment, because it's very easy to simulate a VAPT on a test environment and then actually not do the same thing on a live environment. And to do a VAPT on the live environment opens up risks for all your other customers who are also using the tool. which is a conundrum that we have ourselves not been able to completely crack. So so to your point, Purnima, there is definitely always risk of data residing anywhere outside of your, a place which you are 100% sure of, which in today's day and age is virtually nothing, especially in the electronic data space. But there are reasonable security procedures that most of these cloud service providers and us take, which I think gives most clients that comfort that it's reasonably secure without being 100% secure. So coming back to the original question, and Samir, I hope we still have a little time. Yeah, thank you. From your perspective, coming from the insurance industry, and you were talking about the huge volumes of data that you generate, etc. What kind of support do you think a technology provider like us, legal tech provider like us, can really provide to you?
See, as she said, litigation is the first because we have lots. Especially in general, if you are there, then it is humongously big. Okay, in life insurance, we have enough and more, but not as big as general. But see, as far as the compliance goes, the problem is what I would, if it's a wish, if you can call it a wish for that, is to have something which is in compliance and plug and play. There's a huge amount of time which gets into the setup. Okay, the setup time is, I think, quite big, and that kind of dissuades a lot of people to say, "Oh, itna time nahi hai hamare paas." That's what happens. A lot of people have to give up time, and then they say, "Oh, is it really so important? I have better things to do." So that is something which is sometimes, as a compliance, it becomes difficult for us to push the case in terms of getting technology. Though we keep telling them, "Ki you have this, so you'll get everything on the, you have it on the system, so you don't need to spend time on it. You know what to do. Pop-up will come, they will give you reminders." So you sell the entire package to them in that sense internally. But when it comes to setup, they have this big issue on terms of setting up.
Ganesh, I know that's a problem that you've grappled with on occasions. And my question to you is, it takes 12 to 18 months to set up ERP systems in individual jurisdictions, and people gladly do it and also spend many $1 million in doing it. It takes roughly between 4 to 8 to a maximum of 12 weeks to set up a compliance solution. Yet we find so much of resistance to answering basic questions like, who do you think should be the owner for this set of compliances? Why do you think that's happening, and what can we do better? I mean, to Samir's point, I completely take it that it is an issue. We face it all the time. All our clients are constantly complaining about the time that our lawyers spend in their offices trying to get information and all of that. But what do you think is the reality? How do we draw the balance?
Yeah, I'll answer that. Come to that in a moment. As you were speaking about what more can Lexplosion do in the technology space, well, I think the utopian thought from a customer side. So if I was the CEO or the marketing manager of a company, the utopian situation would be, I don't have a legal department, I have like one guy, I have a Google, it's like Lexplosion answers, you put in your question and it pops an answer at you. And while that utopian space may not exist, but generally speaking, if you work long enough in a corporate legal department, you would get a question on the interpretation of Rule 6 of the package commodity rules about 500 times in a year. So there'll be different marketing managers asking variations of the same question. Can this become a retail sale package, or that become a wholesale sale package, or whatever? And the question is that the opinions that you render on each occasion are typically oral and they don't get archived, and they keep coming back and you're spending man hours answering the same thing over and over and over again. So the technology space here could be that this information, suppose all of us here in this room were to render these opinions into a portal, and sort of there is machine learning behind it and it throws an answer back at a marketing manager. It doesn't cost the company a dime and you can sort of milk a license fee for it. So
sure.
That's a thought.
We'll definitely keep that in mind.
So coming back to the to the question about why is there this hesitation to run a compliance tool, I think the question lies in what the answer lies in what the previous panel discussed. The moment you say compliance or law, it's like that's the job of the GC or the lawyer. It's not seen as an organizational responsibility, as it's seen with SAP, the ERP implementation, or if you do a HRIS implementation, it's looked at as a people-centric thing or a control-centric intervention, accounting intervention. Compliance, that's the job of the lawyer. I don't want to know. You want the budget, take it. It's like a toy. The GC comes and cries for the toy. Okay, damn it, you have your toy. Go play with it. Do whatever you want and run with it. And I think the switch has to be it being linked to the values and the ethical space of the organization and the understanding that it's a shared responsibility. I am not responsible for compliance. It's everybody's responsibility. So make sure you record your compliance on that.
Just to sort of supplement what Ganesh is saying, I think the rationale behind the ERP, the money spent, the time invested, is because there's somebody who spent enough time educating the organization about the risk. And what we need is somebody to invest more time in educating organizations about the potential risk and how we can mitigate that risk by having, technology that can really provide a solution. And it again boils down to the cost benefit analysis and educating organizations about why technology works and why legal technology is as important or will be as important as ERP.
And I think the inflection point could be one inflection point was the Companies Act requiring the director's report to record self-assurance, which is when this whole industry sort of got center stage. Next could be imagine a Supreme Court judgment where which says that if the director or the occupier of a factory was able to show that he did everything that he could to prevent the occurrence, then he wouldn't be personally liable. And in the evidence there is a tool like this put in, and the court says, okay, we recognize the tool. The guy did everything that was possible, so I am acquitting him of all the charges. There will be a queue of CEOs saying, okay, get me that tool because that is my insurance.
When 134.5F came in, one of our clients actually asked us whether we had any role to play in influencing the decision. We're tiny players who obviously have nothing to do with it. We got to know about it on the same day as everybody else did. Now that you place it here, I'm extremely scared that someday there will be a Supreme Court judgment and people will think that we have a role to play in that as well. But it would be brilliant if it actually happens. We are at 7 o'clock or near thereabouts, and I think in the interest of time, we will stop this conversation for the moment. I think I learned a lot. We will take back feedback from here to do more with legal technology. Before we close for the evening from the panel perspective and start the celebrations, my request is there is a questionnaire that we slipped into all your bags. If we are conscious of the ban in plastic, so we have paper bags which you can use for grocery shopping for hopefully the next couple of weeks. If you can kindly take out the questionnaire and please fill it up and give it to one of my colleagues, that would be deeply appreciated. It's anonymous. There is no name being mentioned, no organization being mentioned. So if you think it's possible, we'd really appreciate that. Beyond that, what we also want to do is to take these discussions forward. I think we had a fairly productive few hours. I think Pramod made important points. Moldy and the team and the risk panel made very important points. Data protection, I learned a tremendous amount from the team which spoke. Because legal technology is at the core of what we do and therefore means a lot to us. What we will do is share some insights that we have gathered from these panels and then call on you for more information, more support, more analysis, which we can then present to a larger audience as time goes by. Thank you for being such a wonderful audience. Thank you for being such wonderful friends. Thank you for sparing this time on a Friday afternoon and coming over and helping us celebrate our 10th year. Means a lot, and hopefully we'll see all of you for at least the next few hours here as we try and ring in our 11th, 12th, and hopefully the 20th year at some more time. Thank you very much. Thanks a lot.
The slide.
I just not sure if you will still give a speech on all that is to be correct. Shouldn't be another 5 minutes.
No, it's not. Sameer, thank you very much. So the information remains the same. These are sketches done by a professional organization in Kolkata. If you don't like what you see, let us know. We'll get another one. That's Ganesh. Thank you very much. Thank you, Subhash. Thank you so much. Thanks a lot. And yours will follow. Thank you very much, really. Thank you. Thank you. Thanks. Thank you very much.